Hey, David.
Yeah.
Hey, just to give you a heads up, I believe it's Megan Getz is an attorney and she's trying to get on. She's on through her phone right now, but she's trying to get on through her computer. If she gets on through her computer, she needs to drop off her phone. She can't be on both for the meeting. Otherwise, you'll get that echo.
Okay.
All right. So just so you're aware,
Sounds good. Thank you.
you bet. Hey, Megan.
David, this is Megan. Can you hear me?
Yes.
Perfect.
Okay. So it looks like that you're on your computer and you have gotten off your phone.
Correct.
Perfect.
And I have my clients with me.
Okay. I just wanted to make sure you didn't have both devices going at the same time. Otherwise, we get that echo.
Nope, I dropped off my phone.
Thank you.
So I believe we're waiting for the chairman of Planning and Zoning Commission to get on. Once he's on, then we'll probably start the meeting. So. Sorry about this. Probably a few more minutes here.
This is Bern. Have we heard from our other commissioners? Did they forget this was at 2 o'clock, I wonder, or do we know anything about them, Dave?
Joe just went and called Sean, and I think Sean spaced it, so he's heading to his home to get on the meeting. So
Okay.
I'm not sure about Keith. I haven't heard from him. John, I think maybe waiting at Sean's house.
All right. Okay.
That's my assumption because I did talk to John earlier and he was planning on being here. So
Okay.
I think, yeah, maybe the going back to 2 o'clock messed folks up a little bit. So
Yeah, kind of like going to daylight savings time or something, where it's usually a little bit of a bump.
right.
Hello, David. Can you hear me?
Loud and clear.
All right. I apologize to everybody waiting. Everybody was waiting on me. We'll go ahead and call this meeting to order. Here it is 2:09. I'll call the regular meeting of the Planning and Zoning Commission to order. Will the secretary call the roll?
Mr. Hinckley,
Here.
Mr. Kennedy,
Here.
Mr. Spiegelberg,
Here.
Ms. Hanning,
Here.
and Chairman Moore.
Late, but here. And again, I apologize to everybody for my tardiness. Thank you, David. Looks like all our members are here, so we don't need to excuse any members today. Item number 3 for our meeting today is approval of the agenda. Are there any additions or deletions to the agenda for the September 8th, 2021 meeting?
I do have a comment, Mr. Chairman.
All right, Mr. Spiegelberg, go ahead.
I just received a copy of Mr. Hinckley's letter, presumably to the planner. I guess it's for the intent to get another DEQ study for the McKinney tract. And I don't think it's really, in my view, it's not proper to do this. And I guess that Mr. Hinckley, as I understand after talking with the planner, wanted to incorporate this letter with the McKinney application today. I think that's highly improper. I think it's out of order. I understand that DEQ has already submitted a copy of their findings and so forth. And in looking through Mr. Hinckley's letter, to me, I don't know if who has come up with these figures of the nitrate figure and using this term virgin water is going to be contaminated. I don't see the science, where the science came from to make these remarks. And certainly I'm not a hydrologist, but just as a matter of principle, I really think that that letter should be excluded from the McKinney application today. And to me, it's a procedural matter. I don't know if our chairman, Mr. Moore, was aware that this was going on, but at any rate, I think it's very improper, and I certainly feel that that letter has no part of the McKinney application.
Thank you for your comment, Mr. Spiegelberg. I think get to that at this point. What I guess I'm asking mostly is just, are we going to add or delete any items for the agenda here on the September 8th, 2021 meeting? And I know you're concerned about that letter, and I think that we are going to address that when that application comes forth.
Well, I guess I have a concern that this is, do I understand this, that this letter is part of the McKinney application? Has the planner approved doing that? I just don't think it's proper. And I don't think it's very courteous to the McKinneys who have even, I think they even did a site-specific investigation, as I recall. And I think that's highly, I just don't think that's
Point of
proper.
order, Mr. Chair, point of order. This is totally out of order. We're talking about the agenda. This is out of order. Chair should move on with the agenda.
We'll certainly do that, Mr. Hinckley. I'll reiterate again here, approval of the agenda. Are there any additions or deletions to the agenda for the September 8th, 2021 meeting?
Mr. Chair, I move to approve the agenda as written.
All right, thank you, Ms. Hanning. Do we have a second?
Second.
Second by Mr. Kennedy. I'll go ahead and call roll for this. Mr. Hinckley,
Aye.
Mr. Kennedy,
Aye.
Mr. Spiegelberg,
No.
Ms. Hanning,
Aye.
and Chairman Moore, myself, aye. So move the agenda for today's meeting set. Moving on to item number 4 is approval of the minutes. Are there any correction minutes for the August 11th, 2021 meeting? Has everybody had an opportunity to review the minutes from last month's meeting?
Mr. Chairman, I move to approve the minutes of the previous meeting.
All right, we have a first, we have a second.
I'll second. This is Vern.
All right, thank you, Mr. Hinckley. I'll go ahead and call roll. All those in favor, and I'll do it in order here again, and all those, if you're for or against. Mr. Hinckley,
Aye.
Mr. Kennedy,
Aye.
Mr. Spiegelberg,
Aye.
Ms. Hanning,
Aye.
Chairman Moore, myself, aye, motion carries. Item number 4, disclosures. The chair calls for any disclosures to be known at today's meeting.
Mr. Chair, this is Vern.
Yes.
Yeah, I'm not sure what all counts in disclosures, but perhaps it's appropriate and it speaks to Mr. Spiegelberg's concern. Yes, I have been in communication with DEQ on the manner in which they do Chapter 23 applications, and that's a discussion I've had with folks at DEQ for, 4 or 5 years now, and I have continued that discussion since I was appointed to P&Z, which I think is completely appropriate. But if it's of interest to anyone on the commission, yes, I do speak to my colleagues at DEQ periodically. Thank you.
Sure. Thank you, Mr. Hinckley. Any other disclosures to be known?
None.
None. None. I guess I do have disclosure. Is the application, the Stone Ridge Estate subdivision by McKinney's. From 2000 and 2010 to 2010, actually owned the 40-acre parcel west, directly west of this subdivision proposal. And in 2015, I deeded that ground to a trust, which is owned and operated by my father. So I technically am not the owner, but I just, if people didn't know or aware, my family does have ground that abuts the Stone Ridge Estates subdivision. And I feel like I can look at this application without any bias, for or against. And I don't know if anybody has a concern with that on the planning commission, but I just want everybody to know. All right. Hearing no objections to Mr. Hinckley or myself. Discussion today will be conducted in accordance with the state statutes, the rules of the Planning and Zoning Commission, and other applicable laws. I would ask individuals who would like to speak during the public comment period, please raise your hand, and I will call on you, and we'll give everybody an opportunity to speak. Identify yourself, and please state your address for our bookkeeping. With that being said, we will jump right. Pardon me, Mr. Spiegelberg.
It says here, meeting date September the 9th. Isn't today the 8th?
Today is the 9th. Is that on the front of the sheet?
It's on one of the staff reports.
Okay.
Okay.
Well, we'll just have to adjust that when we.
Yeah, the
We get
staff
there.
report is correct, and then have the
Okay.
other one has September the 9th.
Okay. Very good. We'll get that changed. So we'll jump into public applications. The first public application that we have is the Delbert Johnson variance request. Either David or Joe, would you please go ahead and give us background on this public application?
Yeah, so, Mr. Chairman, this is a variance request from the subdivision standards. I have Mr. Johnson, Delbert Johnson, here in the room with us. He's off the screen. But he's here with us, and he'll have some comments as well. But first I'll go through just a summary of what's going on here. Mr. Johnson would like to divide his property, which is approximately 20 acres in size, into two lots of approximately 10 acres in size. Part of what's required by our regulations is some type of a turnaround, a cul-de-sac or another type of turnaround for vehicles. Also, there's a requirement, so if to build the road, he would also have to provide financial assurance, collateral to build that road until it gets finished. And then also to point out, this isn't a mountainous area. It's right next to Foxborough, up in the Medicine Bow. And this would be considered a mountain view subdivision according to the recommendation of Bill Gorman, the acting county engineer that reviewed this at the time. And so Mr. Johnson is requesting a variance from the subdivision road standards so that he would not need to install the cul-de-sac or a turnaround. The mountain subdivision access standards, which requires two ingress egress from the property, and then the financial assurance that would go along with the need to build the road. And he's got some information about the turnaround and how emergency services can turn around that I'll let him speak to later. But the applicable chapters of the regulations are Chapter 4, Section 4A6J of the cul-de-sac standards, Chapter 7, Section 7, the mountain subdivision cul-de-sac requirement, Chapter 7, Section 13, that requires the two accesses. That's in the mountain subdivision standards. And then Chapter 8, Sections 2 through 4 that discuss collateral and financial assurance for improvements. So the platting and subdivision Variance standards include a number of things that need to be considered. First, exceptional circumstances need to exist where strict enforcement make it, or basically strict enforcement of the provisions of this resolution will result in undesirable characteristics such as undesirable impact to traffic movement, lot design, or utility extensions. Due to the physical surroundings, shape, or topographical conditions of the property, strict compliance with the regulations will impose an undue hardship on the owner. The variance will not cause impacts offsite, such as impacts to traffic, future infrastructure, or storm water drainage. The variance is the minimum modification necessary to alleviate the hardship, and the variance will be in harmony with the intent of this resolution and will not adversely affect the public health, safety, and welfare. The variance will be in compliance with all other adopted county regulations. So just a brief analysis, the turnaround and financial assurance, those kind of go together. If he has to build a turnaround, then financial assurance will be required unless it's built before the subdivision goes through. But only one additional lot will be added if the subdivision were approved. This will not increase traffic or impacts to the area. The county engineer did review it and was okay with the hammerhead turnaround as opposed to a fully built out cul-de-sac. And then some type of turnaround is important to ensure emergency services, firefighting equipment can enter and exit the subdivision. And any improvements need to have financial assurance collateral provided. There doesn't appear to be exceptional circumstances or undue hardships, and this variance could adversely affect the public health, welfare, or safety of folks. And then the second part of this would be the second access road required by the mountain subdivision standards. Currently, there's only one additional lot that's going to be added in this proposed subdivision. This won't increase traffic or impacts to the area at all. I mean, minimally, I guess. The turnaround may be built right across the property line. There's nowhere to connect to secondary access for the proposed subdivision, and none of the surroundings properties have a road that can be connected into. The standards for approval of the variance appear to be met. Then possible motions. So you could request a variance for everything that's being asked for here, the turnaround, the financial assurance, and secondary access. You could recommend denial of the variance, request the turnaround and financial assurance, and approval for the variance of the secondary access, or recommend approval of the variance with all those things. So you could denial on part of it, and then a variance from the secondary access, or approval. So I'd like to have Mr. Johnson, I guess, talk to you about it a little bit. So some of the regulations that kind of come in play here is there is going to be two lots. That's where they need to be able to access both the lots. There already is kind of a road there. And then he'll talk about kind of there's some flat areas where things can be turned around. But I'll let him talk to that. So Mr. Johnson, do you want to go ahead and just talk to these guys?
My name is Delbert Johnson. I own the property up at Elk Run Trail, number 8, the 20 acres that David explained. I was required to put this 35-foot turnaround, or possibly a hammerhead turnaround in, and I basically had a hammerhead turnaround started in there when we made an access road down to the bottom 10 acres that we're trying to sell. And due to the Mullen fire, I have lost quite a few trees up there, and so I have removed some trees, which made this hammerhead turnaround a much easier access. Very obvious. The public is using it as well as for a campground. And I have no issues with putting it on there. What I do ask and request, I guess, if I may, would be to avoid the bond or a letter of credit when I would say that 2/3 of it is there and finished. When delivery trucks as far as rock and gravel, trusses and other trucks are coming into these other properties who lost their cabins as well and are rebuilding, are turning around right there on this turnaround that we are requested to put in. I also have plenty of access and turnaround right at my cabin. There's a little kind of a cul-de-sac turnaround there that has worked well for concrete trucks, semi trucks with belly dumps, and delivery trucks with trusses and so on. Going down to the next 10 acres that will be sold someday, hopefully when we get this all done and approved, we'll have kind of the same thing at their property. They will have a accessible turnaround for everything because they're building a cabin much bigger than what I have, from what I understand. And so their opening for where their cabin's going to set will probably be equivalent to a half acre or more, so they'll have plenty of room for turnaround. But they're on the same page as I am as far as putting the turnaround at the gate or entrance of my property. And I mark Raywald, the engineer, has drawn up a plan, which I think everyone got a copy of from David Gertz, as well as a copy of this map. And I've kind of got a lot of people saying that that's a pretty good turnaround because they can turn a 50-foot fifth wheel around with a pickup truck. And the gas company is coming up to get a gas tank that I set out there for them to pick up. And I've had dump trucks and other trucks coming in, turn around right there. I may have to modify it a little more to come to what you folks would consider a suitable turnaround. But as I talked with several people who's been there already, they feel it's pretty well a suitable turnaround as it is. And so not only the variance of that plus the egress ingress, the variance of the bond or the letter of regret, or I mean credit, sorry, is my other request, just because I feel that it's pretty much there. If anyone was to come up and check it out, I've been told that I've got a state-of-the-art turnaround up there compared to what we have on the forest and in Foxborough or anywhere else. So if a truck with a gooseneck trailer or hauling a machine can turn around there, concrete trucks or rock trucks or anything else, I would feel that it would be suitable, as the word is said in this paperwork, for the fire department or any emergency vehicles. So that is my request, if I may, or my blessing if I can get it from all of you. Thank you.
Thank you, Mr. Johnson. Do we have any questions from the commission for Mr. Johnson? Ms. Hanning?
No, thank you, Mr. Chair. Thank you, Mr. Johnson, for presenting the information.
Mr. Spiegelberg?
I just had one question. Is this land heavily timbered?
It was until the Mullen fire. I've lost about 6 acres of my 20 acres in the fire. And I have roughly, I'm going to go with another 3 acres that the wind has blown down a lot of this. And yes, I'm cleaning it up as we speak. I'm not a young man anymore. I'm going on 67 years old, but I do all my work myself. And I use that wood for firewood for my home and up there at the cabin. So besides rebuilding my shop that got burnt in the Mullen fire, I've been pretty busy this summer with that and trying to fix this turnaround so I can get this property sold to the people who want to get on that property down below. And they'll be cleaning that 10 acres as well. So with all that said, it is getting cleaned up and will get cleaned up in the next year or so.
The reason I'm asking the question is that it's been a very concern of safety in mountain subdivisions that are heavily timbered to make sure there are two escape routes. And that's the reason I'm asking this. I don't have a problem with your turnaround, but I think when you get into a timber situation like that and you get in a forest fire, if you only have one escape route, to me, you're placing yourself and others in danger. And that's my only comment.
Thank you,
To
John.
address that answer, if I may,
So go ahead, Mr. Johnson.
I spoke with, when we went to the meeting on the Mullen Fire earlier this spring, the Forest Service, which was Mr. Romero, about what the Foxborough Association has been trying to get done. And that's several exits out of Foxborough, Somber Hill Estates, and all of the surrounding area. About our second exit, which would be down Wilderness, at the end of that, which would go across the meadow over to 512S on the Forest Service Road that goes into Somber Hill Estates. And I didn't see any progress in getting that road cleared and open to where we'd have a second or third exit if we had a fire. As far as on my property, as David put forth earlier, I do not have a exit because my property borders 5 other properties and the forest. If I was to get permission from the forest to put an exit out across there to attach to this road that I just spoke of, that would go to 512S, then I would also put a fire exit on our property to go out that way, which would be basically going down the southern eastern edge of my property and connecting down at the forest where you can see it's been cleared up. You're looking at the map that I have gave to Dave Gertz and he's given to you. If that was the case, then we would have to see if the Forest Service would allow a road right along the edge of the Forest Service to connect to that road that comes out off of Wilderness. So we'd have a fire exit off of our property to get to that road for a fire exit only. And I've asked the Forest Service if they couldn't do that and just put a sign up saying for emergency uses only. It doesn't have to be an access for people to come and go. It just needs to be for emergency uses only. And I'd put the same thing on my road down my property if that had to be.
Well, thank you, Mr. John. That nation, appreciate it. Any questions, Mr. Kennedy?
None, thank you.
Mr. Hinckley, any questions for Mr. Johnson? Mr. Hinckley, can you hear us? You might be on mute. Well, skip ahead.
Okay, I'm sorry. From my mute key there. No, I had a question for staff though, which we'd skipped over. Can I ask that now? Is that appropriate? Mr. Chair?
You sure can. Go ahead, Mr.
Okay. Yeah, I guess I was interested why the staff recommended denial on the turnaround, and just as a general notion, I don't have an opinion one way or another on it, but we do need to be cognizant of how these things will work with subsequent owners and be careful about not making our decisions based on the representations of the current owners, but rather putting things into plats and so forth that are permanent. So I guess there's my question for Mr. Gertz and his supporters. Are you still feeling that this variance should be denied? And if so, what's your response to this? Again, I have no opinion on it myself, but would like to have your recommendation of denial resolved here.
So I guess my biggest issue is there just needs to be a way for folks to turn around. And Mr. Johnson brought more evidence, to me, just to show that there may be already an opportunity for people to turn around. We would still have to have some kind of an access easement, so that could be used, for emergencies, as well as, at the end of that road. I mean, the road needs to at least end there on his property so that both properties can access that. And I think that's what his intention is. It's just, he doesn't want to necessarily put in that cul-de-sac or a turnaround right there. So my main issues are, we still need to have access to both the roads via, or both the properties via an easement or a road that's built there, whether it's a turnaround or not. I mean, that's one of my big issues. And then there needs to be a way for vehicles to turn around. If there is indeed an opportunity for vehicles to turn around on his property, I mean, if he's willing to put an easement there, then I would be happy with what he's proposing. So.
Okay, no, that speaks to my concern that it be something that's permanent when there are less accommodating owners perhaps than Mr. Johnson. The safety of the facility needs to be maintained. So yeah, if that's adequately covered, as Mr. Gertz explained, I'm fine with it.
All right. Any questions for the applicant? Not hearing any. And I, at this point, don't have any questions for the applicant. At this point, I'll go ahead and open this up to the public. If there's anybody from the public that would like to comment on the variance request, please raise your hand and I'll call on you and I'll give a few minutes here. All right, I don't see any raised hands for anybody that wants to comment. I'll go ahead and close this to the public. Let's see, is there any, I guess at this point, any discussion or is there anybody who would like to make a approval or a recommendation for approval or denial or tabling it at this point? I guess I'll go ahead and ask everybody. Ms. Hanning, any questions for staff or any discussion?
Thank you, Chairman Moore. I guess I do have a question for Mr. Gertz. Can you think of an instance where you've given a variance on the financial bonding piece, but still required a road or like a turnaround or some kind of physical improvement that has to be made that usually would have bonding go with it? Can you think of a time where you've waived the bonding?
The only kind of an outlier situation like that was, I believe that there was an applicant that actually built the road before it was approved, and so we didn't require any financial assurance or bonding with it. That's the only one that I can think of.
Okay, thank you very much, Mr. Gertz. I don't have any other questions. Thanks.
Thanks, Ms. Hanning. Mr. Spiegelberg?
None.
Mr. Kennedy?
My question for staff is, in your conversations with Mr. Johnson, is he willing to make other accommodations so that we could go ahead and grant all of the requested variance with the other conditions that you laid out? Or basically my question's for staff. Is it appropriate to table this so that Mr. Johnson can make some changes and come back so that we could go ahead and approve all of this?
Well, so, Mr. Chairman, the one thing with this is we're just looking at the variances for the subdivision. The subdivision application isn't before us, and so he hasn't really completed all of that. He wants to make sure that we've kind of figured things out before he goes forward. I mean, Mr. Johnson, would you be amenable to putting like an easement on your property so that, like, for emergency only or something, to allow for that?
This one here?
Yeah.
Absolutely. What I was wanting to address as well is it's basically, I would say 2 to 3/4 or not a little more than that done, 85% done. And rather than hold my gate right at my property line, I can move my gate back to my driveway. And then if I get the property sold to these people who are wanting to buy on the 10 acres below, they can put a gate on their access road or their driveway going down, and that'll still be an open area for public, emergency, whoever, to come and turn around on. If there was ever an emergency, I wouldn't think it'd be at my gate. I would hope and think that they would think it would be at my cabin, or the cabin that is being built on the other 10 acres. As far as like a heart attack or somebody fell off a ladder or something like that, I wouldn't want them to come to that turnaround and turn around and leave because there was nobody there. The emergency, in my opinion, would be at one of the other residents, but I have no objection of allowing that area that I have right there to be a accessible turnaround for emergency uses only. Even if it became public, I guess, it doesn't matter. They're using it anyway. The public is using it, everybody's using it.
All right, thank you, Mr. Johnson. Mr. Kennedy, any other questions?
None, thank you.
Mr. Hinckley, any discussion or questions?
With the representation of Mr. Johnson, Mr. Gertz, that adequate formal easement could be provided for the turnaround, I would have no objection to going forward with the variances. And then speaking to Mr. Johnson's last point, there's no reason an easement has to be public. So no one is asking him to dedicate a road to public use, but rather to provide a formal permanent easement to ensure the safety of present and future owners. So again, as I understood what Mr. Gertz said, we could go forward with these variances, pick up the easements on the subdivision. If that's correct, Mr. Gertz?
Yeah, yes.
Then I have no issues and no concerns with going forward with approving the variances. Thank you.
Thank you, Mr. Hinckley. I guess my comment on this is, and correct me if I'm wrong, Mr. Gertz, at this point, we're granting these variances and we haven't even seen a plat yet. And down the road, we will see a plat so that this property will be split into 2 separate parcels, correct?
Yes.
There's been like 5 plats made up already, but because there was something that wasn't met on the plat, it had to be rewritten and platted. And then Mark Raywald came up with this turnaround, and that's the holdup of the last and final plat, is once it's approved by y'all, then they can be a final plat.
Yes, thank you. So my thought on this is, at this point, I think a lot of that's going to be addressed when the platting comes through. I don't see any reason, and again, this is my opinion, to deny any of these variance requests, because at the time when the plat comes through, I mean, Mr. Johnson's going to go ahead and put in this cul-de-sac. And Mr. Johnson, the cul-de-sac's fine by you and going ahead and putting your money forward and putting that into the standard that they're requesting. So I feel like it it's appropriate, and we went at some time, and I don't see an issue with it. So with that being said, do we have a motion from the commission? A motion to approve, deny, or table.
But this is Byrne. I'll make a motion that we approve the variances based on the findings of fact, conclusions of law provided in the staff report.
Okay, thank you, Mr. Hinckley. And so that is providing all 4 variance requirements, just for clarity, for the applicant. Do we have a second?
Second.
We've got a second from Mr. Kennedy. I'll go ahead and take the vote. Ms. Hanning,
Aye.
Mr. Spiegelberg,
Aye.
Mr. Kennedy,
Aye.
Mr. Hinckley,
Aye.
and Chairman Moore, myself, aye. Motion carries for the variances requested for the Elk Run subdivision, which we will hopefully see that plat soon. Congratulations, Mr. Johnson. And we'll move on to the next public application.
Thank you all.
Let's see, the next public application is the Stone Ridge Estates subdivision application SD-03-21. I guess when Mr. Gertz gets done talking to Mr. Johnson, we'll continue.
All right, sorry, Mr. Chairman. You want the next one?
Yes, Mr. Gertz, go ahead and present that to the commission.
Yep, we'll see. Okay, so Stone Ridge Estate subdivision application. This is the preliminary and final plat applications for this subdivision. They're requesting a 7-lot subdivision. This is located at 5115 Maceland Drive or thereabouts in that area. Access to the subdivision is proposed from Quarter Drive, which is the nearest public road. A number of folks reviewed this and provided comments. Game and Fish reviewed it. They noted that there's a pronghorn crucial winter range in the area. They noted things about wildlife movement, pets, roads, habitat enhancements, chemical herbicides, pesticides, and fertilizers, and off-road vehicles, which is in their letter, if you've reviewed that, I'm sure. County engineer reviewed this, Mr. Bill Gorman, who reviewed this. He reviewed all of the application information, and the applicant provided the changes necessary to meet his criteria in his review. DEQ reviewed this. They provided a non-adverse recommendation for this. There was a couple of notes that they required to be on there. One was this, that septic systems and leach fields on lots 1 through 3 shall be, or through 5, shall be separated from the center line of the ephemeral drainage by a minimum of 100 feet. Septic system leach fields on lots 1 through 5 shall be set back at least 100 feet from the lot boundaries. One thing I would note, I did give Dennis Lewis a call today and just discussed with him how long these recommendations are good for. And he did note that they're good for 5 years. And then once these are approved, they're good. I mean, it's up to the county kind of to take care of things. I mean, if this is approved. Wyoming State Engineer's Office is generally supportive of this proposal. City of Laramie provided a letter from Assistant City Manager Todd Feeser. And they requested denial based on non-conformance with all applicable regulations and plans of the city and county. And their letter is attached in its entirety. The fire district's number 1, Luke Hawkins, the chairman, reviewed this and noted that the use of the nearby fire hydrants for fire suppression is adequate for fire suppression in the area. Just a review of the land use plans. The comprehensive plan notes that this is a priority growth area 4. And then this is in the Casper Aquifer Protection area. And so the Casper Aquifer Protection Plan notes that residential areas have been cited as potential sources of contamination to the aquifer. Of particular concerns are septic systems, fertilizers, and pesticides. Water for this project will be provided by individual wells, sewer by individual septic systems. Storm drainage report was completed and reviewed by the county engineer. Utilities are available in the area, clean electricity, and telephone lines are available. Postal service can be or will provide service to these areas. Roads, so there's one interior road that's being proposed that will end in a cul-de-sac. The proposed road will intersect with McKinney Lane, a private road, which then connects with Quarter Horse Drive. The maximum length of a cul-de-sac is 600 feet unless the lots are 1 acre or larger, and the Planning and Zoning Commission approves the variance for this standard. A recommendation of approval of this application is acceptance of this variance. The applicant is required to provide financial assurance for the proposed improvements to the property in accordance with Chapter 8 of the Planning and Subdivision Regulations, and this will need to be provided to the Planning Office prior to final approval by the Board of County Commissioners. Access, the applicant is required to provide evidence satisfactory to the board that adequate access has been provided. The applicant has provided recorded easements that may provide legal access to the property. One easement connects with Grand Avenue. Although a road has not been built along that route, Grand Avenue is state owned and maintained road. And easement also abuts Quarter Horse Drive. The subdivider is proposing to access Quarter Horse Drive, which is dedicated for the public use and maintained by the city of Laramie. The city of Laramie recently adopted a right-of-way access policy. This policy requires approval of a city right-of-way access permit to access property from city roads. And there are questions of whether this permit is necessary to access the property proposed for subdivision. Planning staff will defer to the county attorney's office's opinion concerning proper documentation of legal access. Approval of this application creates a finding that sufficient legal access has been documented by the applicant. Road maintenance, so that the applicant did provide a letter that he will be drafting covenants for this property, and also creating a homeowner association to enforce the covenants. And so we haven't received any draft covenants at this point, which we probably should have those just to make sure that they address the things that need to be. The letter did, I believe, address maintenance of roads and those types of things, and so that'll just need to be put into that document. And then upon approval, the board covenants are filed typically with the final plat, and they'll need to provide documentation to be filed with the state to create the homeowners association as well. Again, fire protection, there's the hydrants that are on McKinney Drive that are sufficient for fire suppression for this subdivision. Aquifer Protection Overlay Zone, this property is within the Aquifer Protection Overlay Zone and must comply with the standards of this zone. The site-specific investigation is not required for the subdivision. However, the applicant has completed an SSI for this project. Notes on the final plat require the septic system to be set back 100 feet from the property lines and from drainage along lots 1 through 5, and this complies with the current APOSD regulations. There's additional regulations as well once a When a septic system comes in, it'll have to be professionally designed by an engineer and geologist before installation, and then installed according to those plans. And then notices has been required as necessary to meet the planning subdivision regulations. Findings of fact, the information provided above in this staff report is incorporated as findings of fact. Conclusions of law, the applicant is proceeding in accordance with the Albany County planning and subdivision regulations. This subdivision is being proposed next to the property that was developed for the same person or purpose recently. The Rocky Ridge subdivision, which was approved by the Board of County Commissioners. It's directly north of the Imperial Heights subdivision, which is within the city of Laramie. This property is contiguous to the city of Laramie, and the southern property line runs along municipal boundaries. The property is zoned rural residential, which allows 2-acre minimum lot size and a 5-acre density, which is the average lot size that can be that has to be met. This proposed subdivision is within the Aquifer Protection Overlay Zone. Vulnerability features have been identified within the reports that have been provided, the site-specific investigation and the DEQ report, and have been noted on the final plat to ensure that wastewater systems are set back 100 feet from vulnerable features as required in those regulations. The subdivider is proposing the use of the nearest public road, Corridor Drive, for access. The lots will be accessed from a proposed cul-de-sac which intersects with McKinney Lane. Corridor Drive is a city street, and the city of Laramie has adopted an access policy that requires the property owner to obtain a right-of-way access permit for access from city-maintained streets. So you have a number of options. You can approve this subdivision. You can approve this with conditions, or you can deny this, or we can continue it to a future meeting. And staff's recommendation includes approval of this application, incorporating findings, fact, and conclusions of law, contingent upon receiving some draft covenants addressing road maintenance for the proposed subdivision roads prior to review and approval by the Board of County Commissioners. Finalized covenants that will need to be filed with the clerk with the final plat, so after it's approved. Documentation necessary to create homeowners association to manage the entity and enforce covenants need to be filed with the state prior to the filing the final plat. And then financial assurance for proposed improvements is provided prior to approval by the Board of County Commissioners, and with the finding from the county attorney that affirms legal adequate access is provided for this subdivision. Is there questions for me? Probably not on this one, right?
Yeah, thank you, Mr. Gertz. Yeah, at this time we'll go around, ask questions of staff. Ms. Hanning, would you like to start us off asking questions to staff?
Thank you, Chairman Moore. Mr. Gertz, well, I want to talk about this road access piece because it sounds like, I mean, the county attorney can make a call, but the city's going to put up, or I don't know, have they already, concrete barriers that would prevent access? So it seems like we're poised for a train wreck if we don't get this addressed in a more straightforward way, in my mind. What are your thoughts?
My thoughts are like kind of along the same line as yours. Is we want to make sure this is right. We want to make sure it's legal. The county's got to protect itself in this instance because we can't deny something based on some other things that may not play into this. I mean, we just need to do what's right, I guess. And what is right, I don't know.
Thank you, Mr. Gertz. Ms. Curran, I see your hands up.
Okay.
Would you like to answer that question from Ms. Hanning?
Thank you, Chairman Moore. Yes, So the issue that the county has at this point, and I have to apologize to Ms. Getz, she sent an email last week and Kurt and I didn't have a chance to talk, and then we were in meetings all day yesterday and I haven't gotten back to her. The difference between this application and Mr. Couthard's application for the property that abuts this Stone Ridge Estates is that the city did not have that right-of-way access policy when we approved Couthard's. So from the county's position, our recommendation from the county attorney's office is that if the Planning and Zoning Commission chooses to approve this recommendation, that it does it with the contingency that the applicant works out legal access to Quarter Horse Road Drive with the city. And that would be a contingency within your approval. Because the county, as you mentioned, Ms. Henning, we can't put ourselves in the position to be interpreting the city's policies, but the city has indicated that the access to Quarter Horse Drive for all of the properties in that area is contentious. And unfortunately, we don't have any way to be able to resolve that for the applicant. The applicant's going to have to deal with the city to do that.
To follow up on that, does that mean then if you were to create that kind of contingency, that no parcels could be sold until that agreement was worked out?
That would be my understanding, yes. When we add the contingencies, the approval is contingent on those things getting done before the applicant can move forward.
Thank you for that answer, Mr. Gerch and Ms. Curran. Another question, Mr. Gerch. So regarding the wildlife corridors and as well being in the aquifer protection overlay zone, seeing what the covenants would do or how they might address some things. You know, for example, I can think of some city of Laramie subdivisions that put into their covenants things about, you know, what kind of activities you could be doing regarding car maintenance, yard maintenance, things where chemicals could be used and inadvertently get entrained into the groundwater. So we don't have these covenants, and we don't even have any firm commitment to what the covenants might contain, and that seems like it makes this application incomplete. What are your thoughts about that?
So yeah, typically it's good to have a draft set of covenants so that we can look at these things. And you know, speaking of the wildlife issues, the Game and Fish brought up, that's typically what will happen with the subdivision, is that they'll try to address some of those wildlife type issues, whether it's wildlife friendly fencing or whether it's limiting the amount of fencing on the properties so that they make sure that there's that corridor. You know, if there's additional items that you would like to see in the covenants that have to do with aquifer protection, you know, that would be where to put those. I mean, and those are things that you could recommend and they can put in before the Board of County Commissioners meeting, or, I mean, obviously there's the option of tabling, and you guys have it determine what you would like to see before it comes back. Because there is a list of things that, you know, we are still waiting for. I know that they're diligently working on getting this information. But yeah, the covenants are something that maybe you would want to look at. But that's, I mean, that's up to the commission, how you would like to go forward with that, so.
Thanks. I just have a couple more questions that I'll try to hurry for. You know, I guess I'll just say up front, I'm sort of leaning towards tabling because of various things missing. But additionally, it sounds like the DEQ call on non-adverse recommendation was lacking some important information. And although they're saying it's good for 5 years, when you talked to him, did he indicate whether they would be willing to redo that assessment with more real-time information?
I didn't actually ask him about that. I mean, the one thing he did say is when they do these reports, they review them. They look at the specific property that's being reviewed. They don't look at the effects of properties around them. And I think Mr. Hinckley's pointed out that's kind of, not really good practice, but that's what they do. And I think that's a statewide thing. That's how DEQ does it. They just look at the property. So whether they consider that property or not, I mean, DEQ is not going to require them to look at that other property to turn in a new report and the potential there. So.
But it sounds like also some of the use of the numbers that Weston used in the SSI were maybe not the most conservative numbers that could have been used in the model. And so I just wonder if those same numbers went into this calculation and whether they're flawed. But at any rate, I'll move on to my next question, which is regarding the SSI and the peer review idea that the city put forth. Have you contemplated whether the county would like a peer review?
So we've never required a peer review on any of these where they're exempt from the standards of the SSI. So, I mean, I almost feel like that's a call that this board or the Board of County Commissioners will need to make. Just because precedent has never been to require it. If the SSI is not required, then we don't require the peer review. That's just, I mean, maybe that's more of a policy, but that's how we've always done it. If we got different direction, then obviously we could do that. But I don't see why this board or, the Board of County Commissioners might want to. I mean, if they wanted that, then that's something we could probably do.
And it sounds like if the county elects not to request one, that the city is simply requesting 30 days for them to have a chance to do their own peer review, which seems like a reasonable request. Given that there's other pieces of the application that are missing, it seems like a friendly request that I hope our membership can honor. Thanks for answering my questions.
Thank you, Ms. Hanning. Ms. Kern, I see your hands up. Do you have something to add?
Oh, I'm sorry, that was accidental. I forgot to take it down.
Oh, okay. Let's see, Mr. Spiegelberg, any questions for staff or comments?
I would like to pose a question to Jennifer Kern.
Yeah, can you speak up a little bit?
Yes, I would like to pose a question to Attorney Kern.
Certainly, Mr. Spiegelberg, what can I help with?
I don't know if you listened to my opening comments at the beginning of the meeting, but I think they were absolutely justified. And there's a letter from Mr. Hinckley, as I read the letter, thinks that we need another study out there. And he introduced some figures. I don't know where he got the other figures from, but in reading the staff report, relative to the Stone Ridge Estate Station staff report, in the reviews, right here at the very bottom of the first page, it says, Wyoming Department of Environmental Quality, a non-adverse recommendation was provided for this application. The following notes must be added to the final plat. And they go on about septic systems and fertilizers. Do you agree with me that this letter from Mr. Hinckley should be set aside? I think once this has been approved by the DEQ, and in my way of thinking, they are the ultimate authority. We are not the authority. They are the ultimate authority. And I think it's relevant too that a site-specific investigation was done by the applicant. What he asked for, and I think it's totally wrong to try to go outside the property boundaries of this parcel under consideration and start studying adjacent properties. I think that's just pure speculation. So I just think that I'm not going to sit and argue with Mr. Hinckley. He's got a right to express his views, but I just don't think it's proper to speak. He's not speaking for me when he goes to the DEQ, and I don't know if he's speaking for the rest of these members here today. But I just think that it's highly wrong to come in at the last minute and want another study by DEQ when they have already stated right in their review a non-adverse recommendation was provided. How much more do you need to say that this has been approved? Do you agree or don't you agree with that?
I would actually, with regard to this half letter from Mr. Hinckley and the process of DEQ, have to defer to David, because with this, regarding the statements he made, that the process that DEQ follows is only to look at the parcel that has been applied for. If that's the standard process for DEQ, then I think whatever additional information is submitted by Mr. Hinckley or anyone else is something that can be taken into consideration in making decisions, but should be noted that the requirements of the permit are the information from DEQ, and that information has been provided. And then I think it's up to each individual member of the commission to weigh how they interpret that additional information and how they interpret the information that is provided to the state, consistent with every review that the state does.
Good.
I agree with most of what you said, Karen, but I just feel maybe the essence of my objection is that this applicant has met all of the requirements and then some. And now that we're on the verge of hopefully approving this subdivision, then they want to add more and more and more, pile on more and more to try to defeat this subdivision. That's my own personal opinion, but I just think it's wrong to come in this late. I just got my letter yesterday from the office, which sent me a copy of Mr. Hinckley's concerns, but I read all this material we get, this packet, I read it from page to page, and it just right there, right on the staff report, it says that it has a non-adverse recommendation. And I think in all fairness to the applicant, I don't think additional requirements should be piled on them when they have already met the requirements.
I mean, I understand your position certainly, and I agree that if the requirements of the permit process and the application process are met, that should be the guiding determination for this board.
Mr. Spiegler, do you have any questions
No,
for staff?
No, thank you, Mr.
Mr. Kennedy?
Thank you.
All right, Mr. Hinckley?
Yes, thank you, Mr. Chair. Questions for staff. The first one was a procedural one. why are we being asked to look at this as a preliminary and final together? And I fundamentally agree with what Commissioner Hanning said. I don't think this thing is remotely ripe for either approval, much less both together. So question for staff, why are we doing this together, and can we do one half of it as the preliminary so that Mr. McKinney can move forward, and then the other, and then clean up on the final? So explain to me the difference between preliminary and final and why we're doing them together here.
Yeah, so Mr. Chair, the applicant asked that these be ran together. There's nothing in our regulations that precludes them from doing that. And so when I'm asked to do it, there's nothing I can say, well, you can't do this. I just run them together when asked to do so. So that's why.
So, Mr. Chair, would it be appropriate for us to do them, to separate them? Is there any reason not to do that if we felt that that was the most orderly way to proceed?
Let's see, Mr. Hinckley, are you asking me or are you asking that question, Mr. Gerch?
Oh, Mr. Gerch, I'm sorry. Through you, Mr. Chair, I'm just trying to explore our options
Yeah,
here.
no, I appreciate the respect, but I'd like to keep the meetings open-ended. You go ahead and ask whatever you need to ask.
Okay, thank you. And we'll try to direct these to staff.
Yeah, so Mr. Chairman, I usually recommend that if there's more than 3 lots that they do go preliminary and final. And I don't think there's anything that precludes you for just, reviewing the preliminary and moving it on at this point, as opposed to both. But that's totally up to you guys. There is I'd have to think it through, but we do have 45 days from the submittal of a complete application. You would have to deem that the final plat's not complete, or then there's a 45 days that we have to make our decision, or it's just automatically approved. And so that's something that we would need to consider if we didn't move the final plat on.
Okay, no, thank you. That's a very useful point. It would suggest that if we aren't ready to move to final, we probably should not move to preliminary and start the clock ticking. Another question, our relationship with the city, remind us of that, and perhaps Ms. Curran can weigh in on this as well. The county is now obligated to solicit public or city comment on subdivision applications within the DONA. Is that correct?
Yeah, we solicit their comments.
And then they submit those comments. Is that the end of it, or are we required to then a response and counter response? I mean, how many times does that ball go over the net before we've fulfilled our legal obligations?
My understanding of the statute is once we submit the application to the city, they have a certain time period to respond. Once they respond to us, if we do not follow those things that they're proposing, then we have to provide a response to them once it's approved, saying this is the reason why we didn't follow some of those things that you're asking for.
But then that's the end of it. There's no rebuttal to that.
Correct, unless the county wanted to do a little back and forth, but that's not required by statute.
Okay. And so that's the substance of the letter that you provided us in draft form. That would be your suggestion for the county's response, formal, legally required response to the city. Is that correct?
Well, it's a draft, yeah. Obviously, it would have to be approved by the Board of County Commissioners. They may have some different ideas. And this is all, assuming that this gets approved. So, yeah.
Yeah, but we're advisory to the county commission. So essentially we're standing in for them at this point, and it would seem to me appropriate for us to consider your letter as though it came from us saying to the board, we think this is the right letter. And I appreciate the head note on the letter to clarify some ambiguity we've had in the past as to whether that's a done deal or not. So thank you for the way you presented that letter to us as potential response. Let me see if I had other questions for staff. I think Commissioner Hanning has pretty well taken care of that. Oh, the a question on the 2 lot average, 5 lot or 2 acre minimum, 5 acre average. You can walk us through that. As I understand it, this is a 5 acre minimum, but Mr. McKinney is suggesting a clustered development. Am I using the terms correctly? And how does the large undeveloped piece count towards that process?
Okay, so the rural residential has a 5 acre density, and then the 2 acre minimum lot size. So the density standard is the average lot size. So if I believe it's around 35 acres of land that he's proposing to develop. So you divide 35 by 7, and that gives you, or excuse me, 35 by 5, and that gives you 7, which is the number of lots that he'd be able to develop. And now the lots can range from whatever size he wants, as long as they don't go below 2 acres, because the 2 acres is the minimum lot size. So he can go down to 2 acres. So 35 acres, he could do, he's getting 7 lots. He can do 6 lots that are 2 acres, and the remainder has to add up to that 35 acres. So he meets that average or that density. So that's how that should work.
So there was a comment, I can't remember where it came in from, that the undevelopable acres shouldn't count towards that. Was there any substance to that comment?
Undevelopable acre?
Well, yeah, I think the idea was that if I had 10 acres that I wanted to put into 2 acre lots, but I'm trying to get my 5 acre minimum, I would buy whatever 30 acres of wasteland right beside it and call that into my average. Are there any regulations that address what land can be included in the average that's undeveloped if it's undevelopable?
No, that's not considered in the 5 acre average.
Okay, thank you. And I'm unclear on the current use of the land. Is Mr. McKinney, is that a commercial operation that's there now, or is that purely residential, or what's the current status of this piece of property?
It's zoned rural residential. From my understanding, he's got a house up there with a shop, and it's for primarily residential uses, from what I understand.
Okay, so our understanding is that there is no commercial use of any of the lot at this point, and that would continue to be the case as we go forward.
That's the assumption, yes.
Is that an assumption or an understanding? Does anybody know?
I don't have evidence otherwise, so that's what I'm assuming and moving forward with. Yeah.
Okay, fair enough. Okay, Mr. Chair, I had some comments on public comments. Would you like to save those? They aren't really staff questions. What's your pleasure, Mr. Chair?
I feel like if you're going to comment publicly, Mr. Hinckley, then at that time when it's open for public comment.
Well, it's commissioner discussion. It's not questions for staff.
Yeah, let's go through. Let's get through asking questions of staff.
Okay.
And then what we'll do is we'll also give the applicant or the applicant's representative, the applicant or the applicant's representative, an opportunity to speak, and also ask them questions. And then we'll also have public comment. And then before we do a vote, we'll have discussion among us members. Does that sound okay?
Yes, thank you very much. Good guidance.
Thank you. Mr. Gertz, this is Chairman Moore. I guess I really don't have any comments or questions for staff. I mean, I think everything's pretty self-explanatory to me reading through the packet. But one thing I do want to address, I mean, I guess it doesn't really matter. I could comment on it now or later, but I'll go ahead and comment on it. And that is what the access issue is. And, I've been practicing real estate in Laramie for 17 years. And, we talk about working with the city and, trying to work with them. And I've been on this commission for 9 years, and we've tried to work with the city in the past. And certainly with Rocky Ridge subdivision or this subdivision, instead of getting a 4-page letter just asking for denial, they've never really asked us for, well, how can we improve areas, or what can we improve? And I hear a lot that from around that, part of the reason why is they want to protect their asphalt, trucks driving up and down that road. And I would believe that if you didn't drive on Laramie roads. I mean, that's not the case. And it's just something to take your eye off the ball. The second thing is I did sell this piece of real estate, not to Mr. McKinney back in 2010 when I purchased my piece. And at that time, we made sure we had insurable access for ingress and egress. And it's my understanding that people in this neighborhood have gotten letters from the city saying they're going to barricade a publicly dedicated road. And which is pretty humorous to me, because I believe that there's nobody else in town that has gotten a single letter from the city who has property in the county that uses or accesses a publicly dedicated road, and a city threatens to shut their access down. And to me, that's targeting. You're targeting landowners in this specific area. And they're not doing it to people that live in Blake Ranch Estates. They're not doing it to people that live in West Laramie. They're not doing it even to themselves with their sewer plant out on Banner Road. When something is dedicated to the public, it is for the benefit of the public. It's for the benefit of the people that live in Laramie. It's benefit for the people that live in the county. It's benefit to the people of Wyoming. It's benefit to people that don't live in Wyoming. That policy and that narrative that's trying to bring up this, well, there's not access, is a complete fallacy. I think this is going to be settled in the court eventually, but I don't think that that's a topic, or I'm not concerned about that. And I feel that it's important to say that, because we as people who are on plan understand what the difference is between something that is publicly dedicated or something that's private. And certainly when a person develops their land, they can either dedicate their roads to the public, or they can maintain them privately, which we've had subdivisions in the past where the developer's chosen that. But to come in at the 11th hour, this land has been owned by Mr. McKinney for over 10 years. To come in right now and say, well, you can't access Quarter Horse Drive, is just unfair. They've known for over 10 years, and the city's never owned that ground. But that's just kind of my comment on the access issue. And in no way do I feel or believe at any point that the city has any right. And even if you pass the policy that they set forth, it's just a policy. It's not an ordinance. They didn't pass it through the ordinance. They passed it. They just actually code. So I think a lot of that's very, very underhanding, and I feel very bad for the applicant. And it's also true the city's tried to do this to me when I owned the piece west of this. The city called YDOT, and they asked to shut me down on a approved access, which the city actually has an easement across my property, and they tried to shut me down. So anyways, I think that's quite a bit underhanded from the city, and I don't even think that should be an issue in this application, because I believe wholeheartedly 100% that the applicant does have access. With that being said, at this point, does the applicant or the applicant's representative?
Mr. Chair?
Yes.
Yeah, I'm sorry. I found one more in my note. Could I sneak in one more question for staff?
Oh, absolutely, Mr. Hinckley. Go right ahead.
Okay. Thank you for your patience there. There was another comment that came through on the issue of the cul-de-sac variance and whether that had been properly noticed. I was wondering what Dave's response to that was. Is it correct that one has to provide public notice for a variance request?
On this application?
Yeah, there's a request for a variance on the cul-de-sac.
Yeah, so that's written into the subdivision regulations. It's what it says is that the standard is 600 feet. If you want to go above that, then you have to have lots that are larger than 1 acre, and planning and zoning has to agree with it.
No,
And that's all it says in there. There's no notice requirement. This is not a process to go with it or anything like that.
well, there aren't notice requirements for variances generically. That's my question.
Not the ones in the platting and subdivision regulations.
Okay,
If it's a
got it.
variance that goes through the zoning, then yes, but for platting and subdivision, no.
Okay, thank you for that clarification. That's all I have, Mr. Chair.
That was a good point, Mr. Hinckley. I saw that too, and I'm glad we got that clarified. At this point, and open this up for the applicant or the applicant's representative to address this commission if they'd like.
Thank you, Commissioner and Chairman Moore. My name is Megan Getz. I'm waving just because we're in our conference room and it's a little difficult to see me. I am an attorney for the applicant for Stone Ridge Estates. With me is Marty McKinney, who is the applicant and also the residential landowner. So to answer Mr. Hinckley's question, Mr. McKinney and his wife, who is a teacher, and their 2 girls live on the property. I think what you'll see them doing is playing softball. If you go by there, I mean, it's as residential as you can get. There is a shop there that, you know, houses their camper and various other things, and also gives some girls some opportunities to play some indoor softball during the winter, which is 90% of our months, it seems like. But other than that, this is as residential as you're going to get. So I wanted to answer that question first. Also with us is Stephanie Portman. Stephanie has been helping with just the subdivision and the application process and just working as a team member with Marty. So we're all here to answer any questions that you might have. I thought I might take an opportunity to just address kind of 3 of the comments or 3 of the themes that I've heard come up. First, I'd like to remind the commissioners and thank you for the work that you do. I know you guys are getting paid the big bucks to sit here and serve our community, but also want you to remember that this application has been in process throughout COVID. And so while everyone has done what it can to keep business moving forward, there were some delays in this process that were caused by COVID. The other very substantial delay in this application was due to the city's policy. And as Chairman Moore has noted, we tried on countless occasions to cooperate with the city. We followed the policy as if it applied to us. And I say that because a policy is not legally enforceable, right? I mean, any community could say, before crossing the lines into Colorado, Wyomingites, you must make sure that your cars operate with this type of emission. And for Wyoming to then say, well, we're not going to let you cross into Colorado borders unless Colorado says it's okay, is really allowing a situation that's within your control to be put in a situation that's uncontrollable. And I certainly appreciate Jennifer Curran and I are very close colleagues and certainly talk on many occasions. And I appreciate the position she's coming from. But I urge the commission not to approve this contingent on the city doing something or the city giving some sort of approval when the commission has no ability to oversee that the city actually follows through. And that's the situation we're in right now. You I'm sure noticed, commissioners, that we pulled this from your agenda because we tried to do the right thing, as Mr. Gertz said. We tried to do the fair thing. We tried to do the right thing. And we went to the city on countless occasions and said, what is it that you want us to do? What is it that you would like in an access agreement that your policy talks about so that we can consider it, let alone do it? And the city came back to us and said, well, actually, we don't know what we want you to do. And actually, we really don't know what our policy is designing to do. And so we can't give you any information. So how can Mr. McKinney and this applicant be held to a standard that doesn't exist? right? How can we go to the city and say, tell us what it is that we need to do to be able to comply with your policy, even if we're not forced to, and for the city to then say, well, we don't know what that is. And so I would just respectfully request you commissioners to not put an applicant that's in the county in a position where you don't have the authority to oversee or determine what the outcome is going to be. It just creates, I would say, an even potential for a larger train wreck than what some may consider is there now. And I would argue there is no train wreck there. Now, when Mr. McKinney acquired the property in 2010, he acquired legal access and insurable title access to access his property. And that was through 2 legally recorded easements, one off of Grand and one off of Quarter Horse Drive through Macy Lynn Drive. So there are already legally established points of access to the subdivision. It's not as if there is private land in between Mr. McKinney and some other public land where we're waiting on a private landowner to give us access. We're saying that the title company, as well as the legally recorded documents, which are the easements, gave Mr. McKinney that access as early as 2010, so more than a decade ago, and he's been operating his land and relying on that access. We appreciate that the city is now trying to consider how it is going to account for maintenance of its city streets. That's perfectly reasonable. That's perfectly understandable, but to require or to not even set forth what those criteria are, and how it may affect one private applicant, not universally determined, just simply isn't a situation that Mr. McKinney should be in and have to respond to this commission on behalf of the entire Laramie and Albany County population. So we would simply request that, like you did with the adjacent subdivision, you do the exact same thing. You follow your own precedent. This is no different than the subdivision you approved just to the northeast, and allow Mr. McKinney to use his property and the means that are permissible under Albany County regulation to divide into 7 small subdivision lots. We're in a housing crisis, and every governing body is talking about how is Albany County going to ever meet this housing crisis. And here we have a very, very modest application for a proposal of 7 homes that would be available to contribute to that housing crisis. Secondly, as it relates to the DEQ, first of all, I'd just like to note for the commission that I'm not familiar with what letter Mr. Spiegelberg is referring to, which gives me incredible pause for concern that if there is some sort of advocacy on behalf of the commission to investigate the application beyond what Mr. Gertz has presented and the Planning Commission has presented, we're really getting into a territory of why judges, and you commissioners are acting essentially as a judge here, of why judges are not allowed to independently investigate a situation that's before them. And that's because it doesn't allow either parties that are at the table the opportunity to know all of the information that is available before them. So, you know, certainly Mr. Gertz has the opportunity to ask questions and require the applicant to provide information, and then that information is disseminated, and it's disseminated among all of the applicants. So respectfully to Commissioner Hinckley, I don't know what his concerns and questions were, but it sounds to me, because we weren't provided a copy of that, and so certainly hope the commission won't rely on that. But more so, if it goes to the process and it goes to what he is asking within his expertise for the DEQ to consider when it's evaluating these applications, that's something separate and apart from this particular applicant's application. This applicant has followed the rules, right? The rules that are written, this applicant has, as Mr. Spiegelberg, I think, noted, done even more, gone above and beyond to provide the criteria that made Mr. Gertz very comfortable to recommend this application for approval before you. So respectfully, if there are changes that Mr. Hinckley or this commission would like to make as it relates to the levels of soils or samples that are being utilized, or what the standard is that's going to be evaluated, certainly by all means talk about that, but talk about that separate and apart from an individual application. It's not appropriate to hold an applicant to a standard that has yet to be created or is questioned. It's only appropriate to hold the applicant to the law and to the standard that's in place before you at this time. With that said, I would simply offer that there was a non-adverse recommendation. The DEQ holds that its recommendations are valid for 5 years, and therefore that standard has been met. As it relates to any further peer review, again, certainly while it's, Commissioner Henning, while it's a great idea to talk with the city and to try and cooperate with them on additional peer review, again, to hold this applicant to a different level than what has been accustomed and the precedent that's been set before would not frankly, it'd be arbitrary. Finally, as it relates to the covenants, my experience, the covenants just have to be available per your own regulations once they are before the commissioners and a final plat is approved. There's going to be nothing unusual about these covenants, and I recognize that you can't take my word for that. But part of the problem of providing even a draft set of covenants with this particular application has been I would say the changing of the guard, or the difference in what the target has been as it's related to different access issues. So it's been impossible to create a set of covenants that will address all of these components when we didn't even know what the standard is. Certainly, please make it a contingency that a draft set of covenants will be presented to the commissioners for review. That's not only totally appropriate, but it's within the realm of what you need to do. And then what we can do is take all of this conversation that you've had today and ensure that it's addressed. But to present a draft set of covenants that then's tweaked or possibly nullified or insignificant is why those covenants by your code are not required until later in the process. With that, I think I've addressed in kind of a bulk theme what has been discussed today. But certainly we're available for questions, but we certainly respectfully request that this commission move this process forward. As for the rest of this country, no one is at fault for the pandemic, but Mr. McKinney has had to be, you know, a product of the end of it. And certainly Mr. McKinney and his subdivision should not have to bear the result of a city policy. Again, not an ordinance, not a statute. And the Wyoming Supreme Court has said that a policy or a land use plan is not law, so it's not enforceable against a landowner. So we would just simply ask that you move this forward so Mr. McKinney has the right to do with his land that, you know, his neighbor was just approved to do not too long ago, and that many other applicants have been able to do. Commissioner and Chairman Moore, unless anyone has questions, I believe that would conclude our remarks at this time.
Thank you, Ms. Getz. Just want to go through the commission, and what we're going to do is, if any commissioners do have any questions, would it be okay to ask you specific questions?
Chairman Moore, of course.
All right, thank you very, very much. Ms. Hanning, do you have any questions for the applicant's representative?
Yes, Mr. Chair, thank you. And thank you, Ms. Getz, for participating in the meeting today. So I guess my question, is probably for you and Ms. Kern. When I look at the DEQ letter of its recommendation, it's non-adverse recommendation. At the end of the letter, there's a disclaimer section. And I don't know if you've read that recently, but in its entirety, it would seem to me to say that nobody is bound by the recommendation, that it doesn't bind the county to the issue. for construction, operation, or modification of water supply or sewage systems. And so, I mean, we can talk about policies and their weaknesses, but let's talk about recommendations and their strength. And it's just a recommendation. The county can take it or leave it. The county can decide that the DEQ approach is not overall holistically protective of all the different existing well owners in the area by not incorporating in the existing nitrate contamination that is in this area, and it's threatening the city wells. And the county is not bound by the recommendation. Would anybody disagree with the disclaimer part of that letter and my take on it? Thank you.
Jennifer, I certainly don't want to jump ahead of you, but I am glad to address the commissioner's comments from my perspective.
Go right ahead, Ms. Getz, and I can follow up after you.
Okay, thank you. Commissioner Hanning, thank you for the question. I understand where you're coming from. The very distinct factor in this particular situation is that the Albany County regulations say that if the DEQ issues a non-adverse recommendation, that is satisfactory for the application. So while you may want to talk about that in policy and change what Albany County's regulations are to allow you to say DEQ is not satisfactory, that would be an issue for another day. So my perspective is DEQ is saying, look, what we recommend here doesn't give any right or cause of action to anyone as it relates to their application. We've been asked to make this finding, and now it's up to the county's rules and regulations to determine if this is sufficient. As the rules and regulations for Albany County are written now, that non-adverse recommendation is sufficient. And so if the county wants to say nitrate levels or adjacent property owners must be considered for the recommendation to satisfy our own regulations, then that needs to change in code. It would be something that Mr. McKinney, under today's present day circumstances, would not be subject to. Thank you.
And just to follow up with what Ms. Getz has said, that the DEQ, not in these smaller subdivisions, because that's been allocated to the county, but the DEQ is the one who ultimately maintains those regulations on a statewide basis. So their recommendation, what my reading of that recommendation language in the DEQ letter is that it's part of the process, and DEQ isn't saying that with this letter, you're guaranteed anything in that process, either from DEQ or the county. I think it's just a standard disclaimer language, and not specifically what they're trying to get around is somebody saying, well, I have this DEQ letter, so I can do whatever I want, even though it may not meet other regulations for the subdivision or the other part of it. They're only saying this is the recommendation for this piece of it and doesn't guarantee the issuance of a permit as a whole.
Thank you, both of you, for your answer. I guess just to follow up, I mean, when I look at the oh gosh, how many alphabet letters do we get up to in the section for approving subdivisions? I guess we go all the way up to R. There are that many requirements that have to be met for approval, one of which is securing the DEQ recommendation. But some of these other requirements for approval, where you're still able to look at septic systems and safety of water supply systems, I don't see them in the regs as being tied to the DEQ recommendation. I see them, because they're all separate alphabet letters, as standing separate from each other. What are your thoughts on that?
Ms. Curran, I think it's probably inappropriate for me to answer that one.
You're okay. I was trying to get myself unmuted. Sorry, Ms. Getz. So I think that individually, those regulations all do have to be considered. The part where, as a commission, you have to be wary of what you're doing is that the requirements that you're applying or requiring of an applicant are based in your rules and are not going to subject this board or the county commissioners to an arbitrary and capricious standard where we're imposing additional regulations that are not written into the regulations on specific landowners.
Well, I guess I'll stop this line of discussion, but I think it could be argued that this isn't setting a new standard. It's trying to bring the full force of our existing regulations to bear. And that maybe they haven't been used as forcefully as they could be. And that all these conditions are already laid out, that they have to show that they're not going to cause contamination of water supplies. And I'll stop this because I know we're just going in circles. But I guess I feel that some of the regs just haven't been fully enforced and that they're not new requirements. It's just more fully looking at what we should have been doing all along. Thanks, and I'll stop now.
All right, thank you, Ms. Hanning. Mr. Spiegelberg, do you have any questions for the applicant's representative?
I just have one comment. I hear this back and forth with DEQ this, DEQ that. I think somewhere in the near future we ought to incorporate a representative from DEQ on this meeting and stuff. And I think you'll find out that they do have the ultimate authority, and I don't know why people keep arguing this.
Thank you, Mr. Spiegelberg. Mr. Kennedy?
I do have a question for Ms. Getz, and is the applicant comfortable with the language in the staff recommendation of the county attorney affirms legal adequate access is provided for this subdivision?
Thank you, Commissioner Kennedy, members of the board. I mean, we would appreciate that recommendation being excluded or stricken. I didn't have an opportunity, as I think Ms. Curran noted, to understand what Ms. Curran's position was going to be prior to just a few minutes ago. And I assumed, and not to Ms. Curran's fault by any means, that the county was not taking a position as to whether or not the city was trying to enforce a policy within county limits. So, you know, we believe that we have adequately demonstrated legal access through the recorded easements that are of public record. And so we would respectfully request that this commission approve this application subject to those easements, as opposed to any further determination of the city's policy.
Follow up from Ms. Kern.
Yes. So the issue that we have from the city perspective or from the county perspective is the way that our regulation is written requires that legal access. While we are not, it is the position of the county that the legal access for this subdivision is directly adjacent to the public road that's dedicated in the plat for Imperial Heights, that Quarter Horse Drive that's in question. There's no gap, there's none of that. The only issue from the county's perspective is this new city policy, and what we are trying to avoid from a county perspective is any further residents or future residences on that road being subject to the policy and the way that it has been implemented and disseminated to other residents in that Imperial Heights subdivision. Mr. McKinney, I'm assuming himself, by way of the letter that he got from the city, and those other residents out there. So what we are looking at from a county perspective is we don't want to create any more county residences that are going to find themselves all of a sudden barricaded off by the city. Whether or not the city's policy is applicable or legal is not a question that we feel we are prepared to determine within the scope of this meeting.
Mr. Moore and Chairman Moore, but perhaps may I just clarify the applicant's position?
Yes, please go ahead.
Thank you. Chairman Moore and members of the commission, in the event the city were to take some sort of adverse action against Mr. McKinney and or his subdivision, we would deal with that with the city, right? We would follow up with the city and figure out and fight that battle then. As you know, we would deal with that then. We would just respectfully request that we understand the county doesn't want to opine on whether that is legal. Likewise, we don't think the county respectfully should put in a condition that we resolve this with the city when it's out of the county's purview to do that. We have legal access, and if the city gives us some sort of obstacle or inhibits our use of access, we will deal with the city as we need to. Right now, I guess, Commissioner Moore, I worry that if the county imposes a condition that we resolve legal access with the city, we're going to be in this situation like we've been in for the last 3 months where the city can't give us any sort of resolution. And certainly I do not mean this as any sort of threat, but I fear that then the county is going to be brought into some sort of legal battle because it's inhibited Mr. McKinney's use of his land based on the city's own policy.
Yes, thank you, Ms. Getz. A good point. Let's see, Mr. Kennedy, are you done with questioning?
I am done. Thank
Okay,
you
very good.
both.
Thank you, and thank you, Ms. Getz. Mr. Hinckley, do you have any questions for the applicant's representative?
Yeah. A few prefatory comments on the issue of the legal access. As I read it, we are required to make an affirmative finding that there is legal access has been established. So we're not creating new regulations here. We're simply trying to obey our regulations. And if one's neighbor is a total jerk and they can't work it out with them, it is not the city's position or the county's position to arbitrate that. That has to be settled between those parties. So I guess I don't see the philosophical coherence of the argument that the county should be, or certainly this body should be adjudicating it. And given your comments as well, Chairman Moore, I have gotten comments from people who live on Quarter Horse who find it highly objectionable that their children are dodging gravel trucks going up and down the road as Mr. Coulthard builds his subdivision. So there are two sides to this. And again, I'm not going to try to resolve that tonight, but I would simply like to place the marker that there are two sides to this. And if the county were to decide to bring a I-80 interchange in on the end of Quarter Horse Drive, that would be utterly unacceptable. So the city has a point here that simply the existence of a city road does not guarantee access to whatever the great wide world might want to bring down that road. I think we should leave that issue between Mr. McKinney and his neighbor, the city. Secondly, Mr. McKinney has legal access across Mr. Moore's land if he chooses to exercise that and cut the city out entirely. So there are options. Mr. McKinney could make this problem go away in a heartbeat. So I think it is completely not just advisable, but is required of us not to approve this thing until it is clear that they have legal access. On the second point, with respect to DEQ, I am not suggesting in any way, shape, or form that the applicant be required to do any more than they already have done. What I am suggesting strongly is that the members of this commission are under a strong obligation to inform themselves as best they can on the conditions of this subdivision. Right now, we do not have a DEQ review of this subdivision. What we have is a DEQ review of a hypothetical subdivision that existed several years ago. My recommendation, and it is no more than that, is that we, for our own purposes, the County of Albany, ask DEQ to relook at their analysis of this subdivision in light of the fact that it exists in the context of several other subdivisions. I guess while I'm on a roll here, if your indulgence, Mr. Chair, to speak very briefly to Mr. Spiegelberg's concerns, and I don't mean to argue with his attempts to suppress comments, but all of the numbers that I have presented are in the public record. They are all documented in the material that I presented. That material was in the packet, to speak to Ms. Getz's point, was publicly available. And I'm a little curious in that I am following direction we got from Council Curran several months ago that we all should be dealing with the same information. I very deliberately presented that information in what I found to be a coherent fashion with documentation several weeks ago so that everyone would have access to it. I'm astonished that that there's some sense that anybody's being ambushed by anything. This has been in the discussion for a very long time. So again, my recommendation with respect to DEQ is that we, this commission, the county, ask DEQ to relook at this particular subdivision, not the generic, if this subdivision existed all alone in the middle of Albany County, but let's look at this one and see what DEQ has to say for themselves. They too are purely advisory, and I completely agree with that. So again, because those 2 points keep coming up, I would like to suggest that we table this until we have resolved the legal access, till the legal access question has been resolved. Let me rephrase that. It isn't up to us to resolve that. And until this commission is satisfied that the technical analysis of this subdivision has been competently and thoroughly reviewed so that we can move forward, meeting our responsibility to safeguard the public welfare and the interests of the citizens of Albany County. Thank you for your indulgence. If there was a question in there that merits a response, we could do that, but I'm not trying to get into a big argument here, simply to lay out the facts as I see them. Thank you.
Mr. Hinckley, and I don't think anybody's taking it as argument. I think, all our discussion, whether it be from me or Mr. Spiegelberg or Mr. Kennedy, Ms. Hanning, I think, we can all differ on our opinions. And so you're very welcome. Did you have a question at all for the applicant or applicant's representative?
No, I did not. Thank you.
Oh, okay, very good. And thank you for your comments. That's why we have this board, So
fair enough.
And as difficult as it is sometimes, we'll get through it and work together, the best we can. So they are appreciated. With that being said, at this point, I don't have really any questions for the applicant's representative at this point. Maybe after public comment, I might. So Ms. Getz, if you just stay available for comments if we need them or questions for you. Thank you. At this point, I'm going to open this up to public comment. And again, with public comment, if individuals who want to speak for or against the Stone Ridge Estate subdivision, please raise your hand on the participants area on the Zoom call here. And I'll call on you and please state your name and your address and we'll get through to everybody. And I know this is a very passionate topic. If people have gone before you and you're going to reiterate the same thing, we still have a long packet to get through here today. Let us know your thoughts, but if you could keep your comments, 3 to 5 minutes, somewhere in there, they'd be appreciated. So at this point, it's open up to public comment. I don't see any hands up at this point, but Mr. Hinckley, you did say that you'd want to speak on this as a member of the public. Is that correct?
No, I simply wanted to clarify that my comments were submitted and they were submitted in order and that they were fully appropriate, whether coming from the public or from me as a commissioner.
Oh, okay.
One can take them however they like, but I have nothing further to add at this point in time. Thank you.
Okay, thank you.
Mr. Chair, I think Mr. Greller wanted to speak.
Okay,
If I may,
let me see. Yeah, go ahead, Mr. Greller.
thank you. Martin Greller, 2667 Jefferson. I just wanted to observe that one of the assumptions that have been talked about, that one ought not be able to consider what's happening on an adjacent property, and specifically with regard to septic and the questions around DEQ. If there's a role for the P&Z in protection of the aquifer, the last septic that goes in is the one that will be the one that causes the failure, in the sense of the straw that broke the camel's back. The fact that there are 50 or 500 other septics out there, that there are other developments, all of them are contributing. So in your deliberation, I would hope that you would remain cognizant of what the incremental impact is, because it is the incremental impact that we will all experience. Another assumption that's being made is that you are on the cusp of a decision, but for some minor matters, this would be going through. And certainly there are some things which are contingencies that you propose to put in. The notion that you may be forced to decide whether you in fact endorse or whether you reject. As a county, the city's decision seems to be part of what a definitive recommendation to the county commissioners would be. But it allows you the time, should you be willing to use it, to give full consideration to what the incremental impact is of this decision. Thank you for hearing me.
Thank you, Mr. Greller, for your comments. Is there anybody else from the public that would like to speak for or against the Stone Ridge subdivision? All right, I guess I do not see any other hands up for public comment, so I'll go ahead and close this application for public comment at this time. Commission, any further discussion items or things that might have been brought up that you might want to ask staff or applicant, or just discussion among us? Ms. Hanning?
No, thank you, Mr. Chair.
Thank you, Ms. Hanning. Mr. Kennedy?
Mr. Chairman, to go ahead and move along, I will move to approve the Stony Ridge Estates subdivision application SD 0321, including the preliminary and final plats based upon incorporating the findings of fact and conclusions of law as stated in the staff report, contingent upon the following: the draft covenants, the finalized covenants filed with the county clerk with the final plat, documentation necessary to create a homeowners association, financial assurance for the proposed improvements, and I would close there, omitting the final line of the staff recommendation.
So we have a first, and do we have a second?
To approve. I so move.
So we have first from Mr. Kennedy, a second from Mr. Spiegelberg. Before we take a vote,
Well, and I did that. That's parliamentary. We should have a motion on the floor before we go into discussion. So,
yeah, and I apologize if I didn't do that correct. Mr. Spiegelberg, do you have any other questions or discussions for committee, for staff or?
Well, is this still a mood issue or is this still a problem?
No, I think it's
Okay, okay, all right. Nope.
no comments or anything. Okay. Mr. Kennedy, any discussion?
And my point is, I agree with you, Chairman Moore, on the access issue. That isn't our bailiwick. Once, if a property is adjacent to a publicly dedicated road, I certainly understand you have to get access from YDOT. But if you're at the end of a road, they can't, if you are physically at the end of a road, they can't deny access if it's public access, dedicated to the public. And so with that, that's why I'm comfortable passing this buck on up the chain. There's no need for us to get involved in that. That's not our purview.
Okay. Mr. Hinckley, any discussion or questions for staff or the applicant?
No, Mr. Chair, I would oppose the motion. I would much prefer that we table it pending resolution of the legal access. It's an interesting discussion. I totally agree with much of what I've heard, that it is not our problem. This is between Mr. McKinney and his neighbor, and it's not up to us to adjudicate it. I would also oppose the motion. I would like to see it tabled pending us taking the city up on its generous offer of a peer review of the SSI at no expense to the county or to the applicant. I would also oppose the motion in favor of one that would have us ask DEQ to give us a more thoughtful review of the groundwater impacts of the subdivision. So on those three bases, I would oppose the motion on the floor. Thank you.
All right, thank you, Mr. Hinckley. Let's see, and for myself, as to this motion, I still feel like, I know under regulations in with the access, but wholeheartedly, I believe that there is no issue, and we're not, it's a non-issue is what it is. And I do respect Mr. Hinckley's comments on there might be upset, sure, with trucks, but that's why we have a police force. That's why we have speed limits, and that's why you have to be licensed to drive in the city, because there's trucks that go all over. I mean, the city of Laramie has dump trucks that drive up and down neighborhoods and through alleys that could pose problems. And so I do understand that. I do get that. And I know neighbors might not be happy with that, but that still doesn't change the fact that people have a right when something is dedicated to the public. And if a person doesn't like that, they can buy a different piece of real estate and live on a private road. Or do as what I did in 2010 and buy 40 acres next to town so that you don't have traffic near you. But that's all I have to say. We're going to go ahead and call a vote here. Miss Hanning.
No.
Mr. Spiegelberg.
Aye.
Mr. Kennedy.
Aye.
Hinckley.
No.
And Chairman Moore, myself, aye. Motion carries, and that'll be sent on to the Board of County Commissioners. We'll go to the next agenda item here, which is the Murphy Land Use Change Application LUC-05-21. Joe?
All right. The applicant was Casey Murphy of Capstone Industries LLC. The legal description is 26 North, range 70 west of the 6th PM, Albany County, Section 6, Lot 6, and Township 26 North, range 71 west of the 6 PM, Albany County, Section 1, the northeast quarter of the southeast quarter, all the way at the northeast part of the county. The request is to change zoning from commercial to agricultural. The property can be accessed off of Camp Paradise Road, a private road. There were 5 reviews. No one had any concerns. Notice has been provided by posted sign, publication, and certified mailing as required. The applicant has provided the required site plans and/or survey. The proposed zoning change generally follows the suggestions of the Albany County Comprehensive Plan, including but not limited to the long-range growth plan and priority growth areas. This property is in priority growth area 4. The applicant has addressed all potential impacts. Findings of fact. The findings necessary for approval as listed in this report are incorporated herein as findings of fact. Conclusions of law, the applicant is proceeding in accordance with the requirements of the Albany County zoning resolution and our staff analysis. The applicant has provided a complete application and has addressed the potential impacts this use may cause. The property is zoned commercial and is in priority growth area 4. The applicant would like to turn in a zoning certificate in order to build a primary residence. Impacts to the surrounding area will be minimal. The applicant has provided information that ensures the impacts and nuisances will change application LUC 0521 based upon and incorporating the findings of fact and conclusions of law as stated in the staff report.
Thank you, Joe. Let's see, do we have any questions from commission? Ms. Henning?
Thank you, Mr. Chair. Mr. Wilmus, what is the commercial activity that goes on right now? Or is there one?
It was a church and then they sold it.
Church camp.
A church camp, sorry.
Oh, okay. And this lot is also being split into 2, is that correct?
No, it's one lot, but it is on the border of 2 different sections.
Oh, okay, okay. So then that was my misinterpretation there.
Yeah.
Thanks for helping me understand that. That's all I have.
Mr. Kendi, any questions?
None, thank you.
Mr. Hinckley, any questions?
Yeah, 2. Why is it necessary? Why is a zoning change necessary for this project to proceed? I'm not understanding what's going on here. Sorry for my ignorance, but why is this zoning change necessary?
Because I believe there's already a dwelling unit on the property or another building on the property, and we couldn't go forward with approving a zoning certificate. So they're required to change the zoning for it.
But ag would allow a second building? I mean, right, an ag zoning says 1 building for 40 acres or 35, right?
So
Again, I'm just not clear.
Right, so I am trying to remember what's going on here. Is the applicant on here?
Yeah. He's right there.
Yes, I am. This is Keith Geis.
So what was it that we were doing here?
The other building that is on the property is an old hunter's cabin of about 400 square feet is all. And we're building a primary dwelling or requesting permitting for a primary dwelling on that property. It is currently being used for ag purposes. The Albany County Tax Assessor requires evidence of that on an annual basis, which I have provided to them for the last 10 years. I was unaware that it was zoned commercial until we applied for a primary dwelling permit.
So, Mr. Chair, I believe I can answer why we're doing this here. Well, one, it'll change to agricultural, and that will be a lesser tax bracket for this property. But I think the more important thing is we don't allow, well, we do allow a second residence. So if to build a secondary residence, he would have had to go through the conditional use process, which is very similar to the land use change process, where he didn't want to use this for commercial purposes. It made more sense to change it to ag, and then he can go ahead and just get the zoning certificate for the second building. It just seemed like the more prudent way to go forward, instead of just keeping it commercial with, commercial taxation and all of that, when all he wants to do is use it as a residential property. So.
Okay, I don't object to this in any way. I was just curious as to why it was necessary. It sounds to me like it's kind of a cleanup application. Is that fair, Mr. Gertz?
Yeah, I mean, it's cleaning up for what the property is actually being used for or wanting to be used for. There's no reason for this to be a commercially zoned property.
Okay. Thank you, Mr. Chair.
Mr. Spiegelberg, any questions on this application?
No questions.
Okay, thank you. And Chairman Moore, myself, no questions on this application. And we did hear Mr. Geis, if you'd like to address us again, or you're fine. If not, that's fine too.
No, I'm fine with my previous comments.
All right, thank you, sir. At this point, we'll go ahead and open this up to public comment. Again, if anybody in the public wants to comment on this application, please feel free so at this time. Again, raise your hand and I'll call on you. And I'll give a couple of seconds here for anybody in the public. Doesn't look like there's going to be, but you never know. Doesn't look like anybody from the public raised their hand, so I'm gonna go ahead and close this to public comment. At this point, being that there's no further comment, there are three options: recommendation of approval, recommendation of denial, or table this application. Do I have a motion from the commission?
Mr. Chairman, I would move to approve the Murphy Land Use Change Application LUC 0521 based upon and incorporating the findings of fact and conclusions of law as stated in the staff report.
Okay, so we got a first from Mr. Kennedy. Do we have a second?
I would so second.
The second from Mr. Spiegelberg. I'll go ahead and call roll. Ms. Hanning,
Aye.
Mr. Spiegelberg,
Aye.
Mr. Kennedy,
Aye.
Mr. Hinckley,
Aye.
Chairman Moore, myself, aye. Motion carries. Application will move on to the Board of County Commissioners. Congratulations.
Thank you. I appreciate that.
Thank you. We're moving on to, let's see, public application number 8, which public application number 8 is the McCardell Land Use Change Application LUC-06-21. Go ahead, Joe.
All right, the applicant is Lori McCardell, located at 183 Gravant Street. The request is to change zoning from small lot residential to commercial. Access is from Gravant. There were 5 reviews, no concerns, but Rob Fisher pointed out that Gravant Fort Buford and Misner Lane are not county maintained. Notice has been provided by posted sign, publication, and certified mailing as required. The applicant has provided the required site plans and or survey. The proposed zoning change generally follows suggestions of the Albany County Comprehensive Plan, including but not limited to the long-range growth plan and priority growth areas. This property is in priority growth area 2. The applicant has addressed all potential impacts. The findings of fact, the findings necessary for approval as listed in the staff report are incorporated herein as findings of fact. Conclusions of law, the applicant is proceeding in accordance with the requirements of the Albany County zoning resolution. Staff analysis, the applicant has provided a complete application and has addressed the potential impacts this use may cause. This property is in priority growth area 2. The property is currently zoned small lot residential. The applicant wants to come into compliance with county regulations for a second dwelling unit on their property, which will require approval of a conditional use application and approval of a zoning certificate application. The staff recommendation is to approve the McCardell land use change application LUC 0621 based upon and incorporating the findings of fact and conclusions of law as stated in the staff report.
Thank you, Joe. We'll open this up to the commission for any questions. Ms. Hanning, you have any questions for our planning staff?
Oh, yeah, I guess so. Mr. Wilmus, this one was kind of a little interesting. Just trying to make sure I'm getting my notes straight. So it seems like it's another attempt to fix a problem. In this case, a second building was put up illegally. Would you say that's a fair representation, or by mistake? Don't mean to call it illegal, but in essence it is. And they have a composting toilet, which I am all for. I'm all for those. I'm not sure where you stand on them and how they fit into the wastewater regs. So we're trying to fix this problem by changing the zoning to commercial, which allows it to have like this rental unit on it. And then we'll have a second adjoining matter for a conditional use permit for a second building or second residence. Am I kind of reconstructing this correctly?
Yeah, that's correct. So from what I know is that I believe there was 2 dwellings on this when the zoning took place in 1997. And then the building got replaced with another one in 2016, which is where it went wrong, kind of, because they didn't know that they needed, to go through this process beforehand when they took that building down. And so now we're here.
Okay. And I guess it's just the paperwork detail on the second companion piece to this. If we approve this zoning, that one would need to be corrected to show the new zoning not being small lot residential anymore. But
Right.
So at this point, you're gonna let the composting toilet stay as is. Yeah, like I said, I'm for composting toilets, but I just wondered how you're proposing to handle that.
So with composting toilets, we do allow them. I guess what we would need to look into is if there's any other water that's coming off, gray water, because that requires some type of a system. Typically, we don't require the tank, but they do have to have a leach field for it to go into. And the applicant maybe can, address how that's working right now. I'm not sure if there's wastewater they're using or what the situation is with that.
Thank you. I'll wait for the applicant to take a turn, but that's all I have. Thanks.
Thank you. Mr. Spiegelberg?
None.
No comments. Mr. Kennedy?
None, thank you.
No comments. Mr. Hinckley?
Yeah, same question as the previous one, I guess, is what are we trying to do here? So there is not a commercial use being proposed. Is that correct?
You got it.
Okay, so this was a little complicated. So the lot is about an acre in size. None of our residential zoning allow for a second residence on that size of a lot. The only way to do that is to change it to commercial, which allows you to have more than one dwelling. You can have multifamily units, those types of things. And then to have a single family residence on a commercial property, then you have to approve a conditional use for that single family dwelling. So this is the only way to fit in what is going on in the property. So, even though, I mean.
And so something like, okay, go ahead.
I was just gonna say that there are many properties down there that already have a second dwelling on this size of a lot. But with the new zoning, that's where this was all precluded, and this is the way to make it right without taking the building off the property.
And our urban residential zoning wouldn't do this?
So with urban
I
residential.
see a shaking of
zoning-
heads.
Maya?
You can only have one dwelling unit on the parcel with that.
But could one go, just remind me, what is the lot density for urban residential?
1 acre lot size for, so it's different depending on what services you have. With just water, you can go down to 1 acre lot size. If you have water and sewer hookup, then you could go down to like 10,000 square feet. But this area
Okay,
is
and
in
these-
a water district with water.
But not on central sewer.
Correct.
Oh, okay. So I was just wondering if there was a better way to skin the cat that made it residential, which is ultimately what it is. So we're using commercial as a way to create a kind of a small urban lot residential. Again, I'm not objecting. I'm just trying to understand.
No, that's
Is that right?
Exactly. Yep.
Okay. Thank you for your creativity. I have, Mr. Chair, thank you.
Any more questions, Mr. Hinckley?
No, sir, thank you.
Okay, thank you. I guess I don't really have question staff. Again, I'm gonna probably comment here more than I probably should, but a few years back, this would have been pre Mr. Hinckley and Miss Hanning on our commission. And I'd have to say it's probably 3 years ago. Is that correct, David? 3 years ago, we had before us regulation that we were working on. And we had submitted a recommendation to the former Board of County Commissioners prior to Ms. Ibarra getting on, and to alleviate this issue, correct?
Yeah, so we had some regulations that were going to allow second residences on properties, yes.
Yes, I believe you brought that up at that time because you foresaw this issue that we need to adjust that. And it got denied at that time. And we had a lot of people come and speak against it because various reasons. And now we're sitting here and of course we want to accommodate a homeowner, a taxpayer, a property owner in our county. And like Mr. Hinckley said, it seems like we're trying to do it the wrong way. And in no way am I against allowing or against what this individual would like to do. Would like to accommodate them with this and appreciate the fact that they're coming in and having it, taken care of. But we can't even take care of them properly, and we're requiring them to do something that all they want to do is maintain their property the way it is. And are we forcing them to do this? Like, it's already out there, correct?
Correct. It's as was stated earlier, it's not on the property legally. I mean, there's not a permit for the second building, nor can we issue a permit because of the regulations right now.
Mr. Kennedy, go ahead.
I've got a question for staff. My understanding was there had been another small building that was a residence and then it was replaced. So if it hadn't been replaced, it was grandfathered in, but when they changed, is that accurate?
So my understanding, the last time there was another building on this property, there was an enforcement letter sent out. Unfortunately, there's not a whole lot of records. The property owner and us, we've kind of went through the records, but we can't find anything where it shows. I mean, maybe a long time ago there was something on there, but the records are very sparse, and we couldn't come up with proof that this was a grandfathered use. That's basically the gist of it.
Thank you, David.
All right. Well, I think you got the gist of my point. You know, Mr. Gertz tried to fix this issue years ago, and we had a bunch of people come in and they just oppose things to oppose things and don't understand why. And I think that's just important for us to understand that we do have a planner that knows what he's doing, and follow his recommendations. And we did at that point, but it was the Board of County Commissioners that didn't pass that, which I was very disappointed at that time. That being said, is the applicant or applicant's representative available? And if you are, would you like to address the commission?
Yes, I'm Juliana Franklin, and I'm actually the owner of the dwelling, the second dwelling at issue today. And I'm working with Mrs. McCardle. She is the applicant in this situation. And I would just like to maybe address Ms. Hanning's questions about the composting toilet and then the issue of subsequent gray water use or septic. The property in question does have a 1,000-gallon tank septic system that is being used by the main dwelling on the property. That dwelling is a 2-bedroom residence, and with the county requirements, it's a 1,000-gallon tank for a 3-bedroom house or 2,500 square feet, and we are under those requirements both ways. So we do use that for gray water, but everything else is composting. So that for the most part hasn't caused any problems. And then possibly to address kind of the question of like when the second dwelling was moved, through our research, we found pictures from 1988 with the second dwelling on the property. And I'd like to, at some point, all these services were put in and have been used pretty consistently since then. I think the issue came up with that residence was moved in the 2015 timeframe when the zoning was changed. But to the point that there was a structure removed, like David said, we couldn't actually find when that structure was removed. I know that the action was done in 2006, but I have Google imaging from 2007 with that residence still on the property. So this is kind of, I would say we're just trying to make it right and get everything under compliance. So I wanted to thank everybody for coming today and sitting through all of this. So that is all I have to say, but if you have any further questions, I'm happy to answer them.
Thank you very much. Appreciate that. Let's see. Does anybody from the commission have any questions?
Yeah, maybe one more, Mr. Chair.
Yes, go ahead.
Yeah, the composting toilet's an interesting thing, but am I correct to understand that's irrelevant to our discussion here? If this goes forward, that second residence can go ahead and put in a certified septic system just like anybody else. Is that our understanding? Maybe I'm back to a question for Mr. Gertz as well as the applicant, but we aren't doing anything that speaks one way or another to how this thing is sewered. Is that correct?
Right. You're not. Yeah, you're right. We're just looking at the zone change in the conditional use. Anything that has to do with wastewater would then have to be permitted after this.
Okay. And we don't have a variance procedure or something that allows a second lot in a special case, or a second residence on the same lot in a special case. I assume you've thought all possibilities, and commercial was the only alternative. Is that correct?
We did. We went through everything, and that was what we came up with. So.
Okay, thank you. That's all I have.
Okay, thank you, Mr. Hinckley. Ms. Hanning, any further comments or questions?
Thank you, Mr. Chair. Thank you, Ms. Franklin, for explaining the system. And I just want to say that I admire your living situation. It's my dream house to live in a small place like that. So I wish I could trade places with you. Thanks.
Mr. Spiegelberg, any further comment? Mr. Kennedy?
None, thanks.
We'll go ahead and the only comment I have is and I appreciate David and Joe going through and figuring out how to make this work, but I feel it's also very unfair to the property owner. And I don't know if I could do anything about it. And I know this is probably going to drive David bonkers, but I sure have an application fee for this because I feel like it's the county's issue, not the applicant's issue. Just my comment. So food for thought. We're going to take a vote. Anyways, can I get a motion from somebody on
public comment? I think.
What's that?
Did you ask for public comment, Mr. Chairman?
I don't know if I did.
I don't think you did.
Let me go ahead and open this up to public comment. And again, throw your hands up. I don't think we're going to see anybody. I'll give 3 seconds here. All right, I'm going to close it to public comment. Do we have a motion from the commission on this?
I would so move.
So we have a first from Mr. Spiegelberg. Do we have a second?
I'll second. Kennedy.
Second from Mr. Kennedy. We'll go ahead and take a vote unless anybody wants to discuss this issue even further. I don't think so. Ms. Henning.
Aye.
Mr. Spiegelberg.
Aye.
Mr. Kennedy.
Aye.
Mr. Hinckley.
Aye.
Chairman Moore, myself, aye. Motion carries. That leads us on to the next agenda item, which is McCardell conditional use application, LUC-07-21. Joseph, go ahead.
Do you need me to go through the whole thing again?
I think everybody's fine with it. I just wanted to give you that opportunity. Does anybody want Joe to go through it? Speak up now if you want Joe to go through it, but I think we're all on the understanding of what this application is, and appreciate Ms. Franklin coming in and going through this. Let's see. We'll go ahead and open up this public comment at this time. Seconds. See no hands up. I'm going to close this public comment. And I'm looking for a motion from the commission.
I would so move to approve.
Mr. Hinckley, I think Mr. Spiegelberg beat you. So we have a first from Mr. Spiegelberg. Do we have a second?
I'll second.
All right. Thank you, Mr. Hinckley. We have a second. I don't feel like we need any discussion at this point. I'll go ahead and call a vote. Ms. Hanning.
Aye.
Mr. Spiegelberg.
Aye.
Mr. Kennedy.
Aye.
Mr. Hinckley.
Aye.
Chairman Moore, myself, aye. Motion carries. Congratulations. And thank you, Ms. Franklin, for putting up with Albany County and being here today.
Thank you all. I really appreciate it.
Best of luck. All right, we're going to move forward here. We're going to move on to public application the Chesser Land Use Change Application LUC-07-21.
Yep. So the applicant is Tim and Lori Chesser, located at 216 Lakeside Drive. The request is to change zoning from agricultural to rural residential. Access is off of Lakeside Drive. There were 3 reviews. No one had any concerns. Notice has been provided by posted sign, publication, and certified mailing as required. The applicant has provided the required site plans and/or survey. The proposed zoning change generally follows these suggestions of the Albany County Comprehensive Plan, including but not limited to the long-range growth plan and priority growth areas. This property is in priority growth area 4. The applicant has addressed all potential impacts. Findings of fact, the findings necessary for approval as listed in this report are incorporated herein as findings of fact. The applicant is proceeding in accordance with the requirements of the Albany County zoning resolution. The staff analysis, the applicant has provided a complete application and has addressed the potential impacts this use may cause. This property is in priority growth area 4 and is zoned agricultural. The applicant wants to add a second dwelling unit onto their property, which will require approval of a conditional use application and approval of a zoning certificate. The applicant will need to follow Albany County wastewater regulations for a septic system if a new system is needed. The staff recommendation is to approve the Chester Land Use Change Application LUC-07-21 based upon and incorporating the findings of fact and conclusions of law as stated in the staff report.
Thank you, Joe. Do we have any questions from commission for staff? Ms. Hanning?
No, thank you, Mr. Chair. I don't have any questions at this time.
Thank you, Ms. Hanning. Mr. Spiegelberg?
None at this point.
Mr. Kennedy? Mr. Hinckley?
Yes, I do. Thank you, Mr. Chair. The first one, did Jennifer, no, she's still there. First one is for Jennifer, and it actually applies to this and the previous 2. Zoning is creation of regulation, if I'm understanding our previous conversations correctly. So and this is a question I asked Ms. Curran earlier that we never finished the conversation, Jennifer. How is it that zoning changes go through without the same notice and process, 45-day review at the county commission as zoning originally? When aren't those the same thing procedurally? What am I missing there? Again, I'd asked you this earlier, and maybe this is a chance to sort this out.
So clarify for me, Bern, what you're talking about. So what's in our zoning resolutions,
right,
is what has to be followed when making decisions.
Okay, let me try again. If we were starting de novo, blank land, and we said, I want this piece of ground to be zoned agricultural, that would be our zoning resolution. And that would require the full public comment notice and so forth, correct?
Correct.
Okay, so now we're looking at a piece of ground and we're saying, I want this piece of ground to be zoned rural residential. Why is that different?
You are not changing the definitions of agricultural or rural residential. You're changing the way the property itself is classified. And those changes are allowed within the regulations themselves.
Okay, so even though the effect is that, so the map is not part of the regulation and the creation of regulation.
Correct.
Okay, that strikes me just curious, but okay. So that kind of accepted itself. All right, the second question is more of a planning one for the planning staff. This sounds like it's the absolute essence of spot zoning, that right out in the middle of this sea of agricultural zoning, we're going to have a rural residential zone. Tell me about that.
Spot zoning would be more of smaller lot, I mean, 35 acres is, or 40 acres is quite a big chunk of property. I mean, if you're looking at zoning within a city, 40 acres, that's, that's hundreds of houses, right? So, and really the use is not going to change that much, other than there's going to be a second dwelling on the property. So I would not consider this spot zoning in that the size of the lot is huge. I mean, if it was just like a little commercial lot in the middle of there, then you're changing things around a little bit. You're creating a use that has more impacts on the area, where agricultural to residential, there's really not that many impacts. I mean, agricultural can be used for residential purposes as well. I mean, it's used for housing all the time. It's used for outbuildings. And so I wouldn't consider that problematic.
But okay, as I'm picturing it on the map, I'm going to have this 40 acres in the middle of everything else that's different. That's correct, yes?
It would be a different color for sure, yes. The uses per se wouldn't be any different, because that's
and furthermore, well, okay, let's speak to that for a moment here. And it goes back to my comment that we should not make our decisions based on the intentions of the personalities currently on board. If this 40 acres were zoned small lot residential or rural residential, it would allow for a subdivision at 5-acre lots at the discretion of the new owner. And there would be no discretion on the part of this commission to change that, right? They would be within their rights under rural residential zoning to chop that into 5-acre lots, or to chop it into 2-acre lots with one big one to keep a 5-lot acreage average. Is that correct?
Yes, if the zoning was changed, they would have that ability to create a subdivision of average of 5-acre lots on that property. I mean, kind of an aside, Wild Horse Ranch wouldn't allow that. Their covenants only allow 10-acre lots or larger. But I mean, for our rules, yes, they would be able to do that.
Okay, which strikes me as a very dramatic change in the character of the Wild Horse Ranch Big Hollow properties, and contrary to how that's been represented over time. I'm opposing this change, not that I'm not sympathetic to someone putting a second lot on, but because we don't want to have rural residential level densities out in the middle of these 40-acre lots. And it is contrary to what all of the other lot owners had every expectation for the future when they bought their property. So as long as I'm understanding what's on the table correctly, which it sounds like I am, I think we should deny this proposal. Thank you.
Thank you, Mr. Hinckley. Mr. Gertz, I'm actually going to follow up with Mr. Hinckley, same line of questioning. What's the purpose of changing this from agricultural to rural residential?
So again, I mean, this comes back to your, the situation with the McCardle property. The only way to allow for a second dwelling is to change it to rural residential. I mean, that's the only way they can get the second dwelling on the property.
Okay, so it's a second dwelling again is the issue in agricultural, or rural residential allows you to do that with this amount of acreage, correct?
Right, and that's again where you've stated it earlier, this is problematic. It's, if someone goes out there and buys a 35-acre lot and they assume they could put a couple cabins on the lot, but they can't, not without a zoning change to do that.
So I realized, I asked you the question because I realized the answer, because it leads back to the line of questioning from the previous application is we've tried to fix this issue. You, as our planner county, has tried to fix this issue in the past, and we've gotten denied. And as far as I know, and I'd have to relook at it because I've sold property in the Wild Horse Ranch before. I believe that in their covenants, and correct me if I'm wrong if you didn't look at them, but I don't believe you can subdivide property based off their covenants. Now, we're totally different than, I mean, we're governmental rule, that's civil, you know, and so by us allowing that, the applicant could come back down the road, this owner or another owner in the future, and say, yeah, we want to subdivide this now. And I think that it's very important that if we do grant this, that we also realize that we're not trying to create a civil issue between people that live, like what Mr. Hinckley said, that people that bought the property out there that understand that this is why they bought it, that's not necessarily going to change unless the whole subdivision wants to get together and engineer covenants. I also believe too that the subdividing on it, and again, the difference between governing with zoning and covenants, which are a civil matter between landowners. I believe also the Wild Horse Ranch only allows 1 acre of development on their property. Do you remember that off the top of your head, David? I think that's. Turn your volume on. Yeah. And I should bone up on that more and be sharper on that. But anyways, I guess that's the only comment I have. At this point, the applicant or applicant's representative, if you'd like to address, and I see Christy's hand up here, if you'd like to address the commission, now is your time.
Hi, yes, I'm Christy Roberts with Dwell Inc. and I am here on behalf of the applicant this afternoon / evening. I do just want to comment that the existing residence on the property is what most of us would consider a cabin, and the property owners purchased this property with the intent of building what we would consider a single family residence. And in the note of the discussion that we've been having, similarly, the county regulations don't have any sort of definition of single family residence, you know, whether or not it has a kitchen or things like that. The city has a little bit more definition of that. And maybe that would be another easy way to look this in the future. But I'm available for any questions that you may have.
Thank you, Christy. Let's see, I guess I'll go through the commission here. If you have staff's representative, Ms. Hanning.
No questions for me. Thank you.
Thank you. Mr. Spiegelberg?
None.
Mr. Kennedy?
None, thank you.
Mr. Hinckley?
It sounds like we're being asked to approve a 7-lot allowance. Is there no way to classify this as an outbuilding or something? Again, I guess this is a combination of Christy and David. Is there any other way to crack this nut? If in fact the owner simply wants to put in a nicer house, maintaining the overall character of Wild Horse Ranch, are we convinced this is the only way to allow that to happen? I don't want anybody to have to go tear down that cabin, but can it be declared a guest house, and does that make it legal? What else can we do here?
We reviewed what was going on, and this was the solution that was available. So, unfortunately.
Okay, I have no other questions for the applicant. It seems clear what they have in mind.
Thank you, Mr. Hinckley. No questions for the applicant's representative for me. So at this time, we'll open this up to public discussion. If there's anybody from the public that wishes to comment for or against this application, now is your time to speak. Seeing no hands up, we'll go ahead and close this to public comment. At this time, I'm looking for a motion from our commission on whether to approve, deny, or table this application.
I would move to approve this application.
So we have a motion to approve from Mr. Spiegelberg. Do we have a second?
Hanning will second.
Okay, so we have a second from Ms. Hanning. Do we need some more discussion on the board?
Mr. Chair,
Yes, go ahead, Bert.
it's an interesting series that we've been through these last several months where we don't really have the tool that we want, that it seems to me we are straying ever further from that tool, the tools being available to us to do the job. It sounds to me what we're picturing here is approving the potential for a 7-lot subdivision in the middle of Wild Horse Ranch, which I think is objectionable to everybody who lives out there. And perhaps the better solution here is to deny this application, which is where my vote will fall, and work on getting regulations that do what they need to do, rather than bending and contorting ourselves to apply a tool that really is very poorly suited to this problem. So that's the substance of my opposition to the application. Thank you. But we can change regulations, let us recall.
Yes, and Bern, I agree with you wholeheartedly on this. David, can we, and maybe this is a good question for Ms. Curran, but can we approve this application with the condition that it remains a single lot? Or is that way out of our scope?
So if you're gonna approve new zoning for the property, then the regulations that go with that zoning go along with it. There's not really a way to condition it. I mean, I guess on the conditional use permit, but that's just for the dwelling, the second dwelling, so. I don't know.
I mean, because
the other comments, I don't think you can, so.
Because what I mean, I want to very, very badly vote to approve, but also I think it's very important that we do not create a civil matter between landowners in, even though that's outside of our scope. I mean, essentially that's what we'd be doing if an individual decided to subdivide their land and came back through this body, a planning commission, and approved a plat, like Mr. Hinckley saying. So I don't know, Ms. Curran, would you please, do you have any thoughts as our legal counsel?
As has been noted, if you do change it to rural residential, it would, within the county zoning regulations, allow for subdivision of that lot down to 1 residence per 5-acre parcel. I can tell you that previously, when there have been questions from the planning office regarding how covenants apply to any type of proposed application, our office has read the associated covenants and provided response back to the planning office to say, this doesn't appear to allow, the covenants don't appear to allow division, or the covenants do appear to allow division. So that's not a guarantee. We can't always be sure that we are meeting the regulations or the covenant requirements so that we're not creating an issue. In quickly glancing at what has been filed with Wild Horse with regard to their covenants in phase 1, they seem to allow, so long as the lot owner is in compliance with the county zoning regulations and not one of the zoning, or not one of the parcels that are specifically delineated within their covenants for having additional setbacks or no division. They do allow division of lot sizes down to 10-acre parcels. So that's all I can tell you there. What you choose to do with that is certainly up to you and up to this commission.
Mr. Chair, I know Christy has her hand up. I also have some comments, so.
Absolutely. Go ahead, Christy.
That, my comment was just covered. I just wanted it to be noted that the covenants have a 10-acre subdivision limit, so. I'm good, thank you.
Thank you, Christy. David, what additional comments could you provide us?
Well, first I would say that I think the damage is already done in this area, per se, damage, I guess. Because when this was created, Wild Horse Ranch, it was created through an exemption at the state level. So the county couldn't even regulate these. So you now have a subdivision of 35-acre lots that, you know, goes from 130 to 230. There's, I think, over 200 lots. I can't even remember. Maybe it's more than that, 200, 300 lots or something out there. And so you've got all of these 40-acre lots out here. I'll point out that there have been a number of family divisions that have happened out there. So these 40-acre lots are now 10-acre lots in some areas where they've given these parcels to different kids. And so these divisions are already happening out there, right? In addition, I will just note, for good or evil, the county has already approved a number of these zoning changes to allow second residences on the property. I'm not sure exactly how many right in Wild Horse Ranch. I know, I'm thinking of one I know that we approved. There's one that was down not on Brittany Lane, which is a kind of a similar situation, but not in Wild Horse Ranch, where we approved a zoning change and then the additional dwelling. And again, like, I'm not condoning any of this, but these are the things that have been done, and this is the situation here. So I wanted to provide that background while you guys are discussing this.
Thank you, David. From Commission. I think we probably had a lot of discussion here. I believe we have a first and a second. We'll go ahead and take a vote. Ms. Hanning.
Although I seconded, I have concerns about solving the problem this way. I know you're trying to take a vote, but can I just ask David one more question to see if there's another way through this? In the land use,
absolutely. Go ahead and ask David, and then I'll call for a vote after you're done. But go right ahead.
Thank you, Chair, for allowing some unusual stuff. We're all getting tired. In the land use table under accessory uses, where it allows additional dwelling or an accessory building. In this case, if what we're talking about is more or less considered a cabin, it still, you would say, meets our not very good definition of a single family home, and that's why putting a second single family home out there is a problem? Or can you call this cabin an accessory building?
So an accessory building wouldn't be used for living type purposes. And so we would consider it a single family home, the cabin and the new home.
Okay, thanks. Sorry for the last ditch attempt to come up with a cleaner way to do this. If you want, I can take my vote now, Chairman Moore.
All right, but no, I appreciate your willingness, because I think we're all kind of in the same boat where we like to help people out, try to make things work, but we also, like Mr. Hinckley says, we've got an issue, which I agree with. But let's go ahead and take a vote. Ms. Henning?
I'm falling onto the I side of the fence I just fell off of.
Okay. Mr. Spiegelberg?
Aye.
Mr. Kennedy?
Aye.
Mr. Hinckley?
No.
And Chairman Moore, myself, aye. So motion carries 4-1. We'll move on to the other application that goes along with this. If I can get this pulled up here. Let's see, the Chester conditional use application, CU-04-21. Joe, is there anything other than what you explained to us before that you need to go through?
Nope.
Doesn't sound like it, does it?
No, we're good. Nothing to add.
Okay. Yep. Okay. Very good. Anybody from the commission? I guess I'll go through. Ms. Hanning, any quick questions for staff on this?
No, thank you, Mr. Chair.
Okay, Mr. Spiegelberg,
None.
Mr. Kennedy,
None.
Mr. Hinckley.
No, thank you.
Thank you, and Chairman Moore, myself, none. At this time, the applicant's representative, Ms. Roberts. Anything you want to add?
No, thank you.
All right, thank you. At this time, we'll open it up to public comment. I don't think we're going to see any, but we're certainly going to give a few seconds here. All right, not seeing any public comment. We'll close this to public comment at this time. At this point, I guess I'm looking for a motion from the commission on whether higher table this issue.
I'll move approval of the Ladybug subdivision as per.
Mr. Hinckley, sorry, we're on the Chester conditional use application.
Oh, I'm sorry, the second one of that.
Yeah.
Sorry. I'm trying to get ahead of myself. It is getting late indeed.
Yeah, we still have Ladybug next, so.
All right, I got Ladybug in my sights.
All right. Do you still have a motion to approve, Mr. Hinckley?
No, I'm good. I need to catch up with my notes here. I turned the page too soon.
Okay, so I'm looking for a motion to approve, deny, or table the Chester conditional use application.
Mr. Chairman, Kennedy, so moved.
All right, we have a first from Mr. Kennedy. Do we have a second?
I would so second.
A second from Mr. Spiegelberg. Okay, we'll go ahead and take a vote on this. Ms. Hanning,
Aye.
Mr. Spiegelberg,
Aye.
Mr. Kennedy,
Aye.
Mr. Hinckley,
No.
and Chairman Moore, myself, aye. And so Chester conditional use application CU-0421 is approved and moved on to the Board of County Commissioners. And I do, Mr. Hinckley, I do appreciate your vote and the reasons why. We're going to move on to the next application, which is the Ladybug Ridge Subdivision Application SD-04-21. And that looks like that's Joe's to present to us.
All right, so the applicant and owner is Susan Faraday, located about 5.5 miles north of Laramie. The request is to approve the preliminary plat. Current zoning is rural residential, current use is vacant. Access will be from US Highway 30, and this application will be reviewed as a small subdivision. There were 7 reviews. Luke Hawkins, chairman of the Albany County Fire Department, number 1, had no concerns but recommends the whole water program. Albany County Assessor's Office Karen Bowman had no concerns. Albany County Engineer Bill Gorman had some comments, but they've been addressed. Albany County Engineer Jake Schneider had comments, but those comments have been addressed, and he has no comments since the change from 3 lots to 2 lots. Albany County Road Bridge, Rob Fisher had no concerns. YDOT, Ryan Shields had comments about drainage and access. The full comments can be seen later in the packet. Drainage will not be affected and access has been taken care of. Wyoming Game and Fish, Amanda Loesch has no concerns. This property is in priority growth area 3. Water will be provided from individual wells. Sewer will be individual septics that will need to be applied for through the Albany County Planning Office. A storm drainage report has been completed for this proposal and reviewed by Jake Schneider. Carbon power is existing in the area. No natural gas service is known to be existing. Postal service is existing, and the post office will provide service to all new lots. There's one new road, which is the required turnaround. Its name is Sunflower Court and has been approved by the Albany County Addressing Coordinator. Road maintenance covenants will need to be written up for this, for the final plat with provisions covering road maintenance. Financial assurance will need to be provided with the final plat. Fire protection will be provided by Albany County. Notice has been provided in accordance with Albany County Platting and Subdivision Regulations, Chapter 4, Section 9. Findings of fact, summary of the subdivision requirements listed in the staff report shall be incorporated as findings of fact. Conclusions of law, the applicant is proceeding in accordance with the requirements of the Albany County Platting and Subdivision Regulations. Staff analysis, this application qualifies to be reviewed as a small subdivision in accordance with the Albany County Platting and Subdivision Regulations, Chapter 4, Section 6, and has met the standards of this process. The preliminary plat complies with the Albany County Platting and Subdivision Regulations. This property is zoned rural residential and is in priority growth area 3. The subdivision is being proposed in an area that has previously been developed into a residential community. The lots will be accessed from US Highway 30. The addition of 2 lots into this area should not create any substantial impacts to the area, and fire safety requirements have been waived by the fire warden. Staff recommends approval of the preliminary plat for the Ladybug subdivision preliminary plat application SD 0421 based upon and incorporating the findings of fact and conclusions of law as stated in the staff report.
Thank you, Joe. Do we have any questions for staff? Ms. Hanning?
No questions at this time. Thank you.
Thank you. Mr. Spiegelberg?
None.
None from Spiegelberg. Kennedy?
None, thank you.
Mr. Hinckley?
No, thank you.
None from Mr. Hinckley, and Chairman Moore, myself, none. At this time, I'll open this up to the applicant. If the applicant wishes, you're more than welcome to address the commission, and if not, that's okay too.
Well, we're just, it's a family well, it's just a mother-daughter thing, so we're not selling the lot.
Well, very nice for you to join us here, and apologize that you have to be the very last one.
I know, I didn't figure out forever that you could like turn my video off. So it's like, gosh, I could have been cooking and cleaning. I thought I had to sit here the whole time.
Well, thank you for being here. I guess at this point, does anybody from the commission have any questions for Ms. Faraday? Ms. Hanning?
I just want to make sure that you're following all of these drainage recommendations. I worry how close you are to the floodplain, and just I know that you and your daughter are probably watching for that, but I appreciate the careful job that Jake Schneider did in looking over the drainage report. So I just hope you stay safe out there. Thanks.
Oh, thank you. Thank you.
Mr. Spiegelberg, any comment or question? None. Okay. Mr. Kennedy?
None, thanks.
Mr. Hinckley?
No, thank you.
Thank you. And Chairman Moore, myself, none. At this point, I'll open it up to public comment. I'll give a couple seconds here. Not that I see any hands. We have very few on our list here. I'll go ahead and close this to public comment. At this point, we're going to go ahead and take I'm looking for a motion, either a motion to approve, deny, or table this application.
Mr. Chair.
Yes.
I move that we approve the Ladybug subdivision.
I'm glad you got in there.
I knew I was going to have my chance.
I'll
Consistent.
second that.
All right. there
All
we go.
right, very good. So we have a first from Mr. Hinckley, a second from Mr. Kennedy. We'll go ahead and take a vote here. Ms. Hanning,
I,
Mr. Spiegelberg,
Aye.
Mr. Kennedy,
Aye.
Mr. Hinckley,
Aye.
and Chairman Moore, myself, aye. The motion carries. Congratulations, Ms. Faraday, and your application moves on to the Board of County Commission.
I do have one thing to say. I decided after listening to this, the ladybug came from a favorite horse that we had for 20 years, and my daughter loves sunflowers. And I'm listening to all this stuff, and I'm like, oh my goodness, I could have named it something more manly. But anyways,
I love it.
Wyoming, and we're
No, it's a great name. You chose
Yeah.
great. Best of luck to you.
okay. Thank you.
Okay, so it looks like at this current juncture, we're done with public applications, current planning projects. We don't have any, though I think it should be noted. And David, if you wouldn't mind bringing back a recommendation to our board, or maybe even speaking to the Board of County Commissioners about this issue that we have with secondary units, secondary homes, not primary residences on lots in certain zonings. That needs to be worked on. And I do realize that you did do this 3 years ago, and I think it is time to bring it up, because I think today was a very good example of why we need specific regulations, and why you tried to address this 3 years ago. We wouldn't be having this issue today. So if you wouldn't mind addressing the Board of County Commissioners on that, and maybe working on that, bringing that back up to us, because that would be great. With that being said, we'll move on to other items and announcements, which the next meeting is October 13th, 2021 at 2 p.m. I'm going to make sure that I note that it's at 2 p.m. And again, I apologize to everybody that's still on this call and the other commission members. I had wrote it down for 4, and I apologize that I was late today. Any other citizen comments? I don't see anybody else online at this point. And we've had a long meeting. I guess unless there's any other comments any other members have, I guess I'll go around and ask. Ms. Hanning, is there anything you'd like to bring up or talk about this, discuss at this point?
just regarding this, the 2-house problem where a house exists already seems like a separate nut to crack. But it seems like dealing with potential second dwellings on 35 acres or more, couldn't that just easily be dealt with by changing our land use table to allow it through a conditional use permit, so that we didn't have to go through all this rezoning and just make it something that can be considered on a case-by-case basis under the conditional use umbrella? Thanks.
Thank you, Ms. Hanning. That's very sound logic. I agree with you. Mr. Spiegelberg, any other issues you want to address at this point?
None.
Okay, Mr. Kennedy?
None, thank you.
None. Mr. Hinckley?
Just one for Chairman Kennedy's amusement. Back in March or so, I was lobbying for 6 o'clock meetings, and he successfully convinced us all that 2 o'clock was a more accommodating time. I'm 8 time zones away from you guys, so yeah, I'm glad we didn't start at 6. Thanks.
Oh my goodness. Well, wherever you are, good vacation or good trip. And thanks for joining us while being away.
You bet. No, this is a marvel of the internet, isn't it?
Yeah. Well, very good. Well, you enjoy yourself, and thank you. And no other comments from me. So do I have a motion from any members of the commission to adjourn this meeting?
I would so move to adjourn.
First from Spiegelberg.
Second.
Second from Kennedy. I'll go ahead and take a vote real quick. Last one of the day, Ms. Henning.
Aye.
Mr. Spiegelberg.
Aye.
Mr. Kennedy.
Aye.
Mr. Hinckley.
Aye.
And Chairman Moore, myself, aye. Meeting's adjourned, and we will talk to you next month. Everybody take care and be safe.
Adios.
Hey guys, thank you.